Yes, Mr. Majumdar.
Item number 2, I have filed on additional affidavit, but it is not on the record. So it can be placed on the record and third, a matter may be taken after some time. The meantime, I will place it.
You have a copy, extra copy?
Yes.
May I please look? One writ petition may be listed on Monday for necessary order. Interim order is required. Because some development is going on there in the DOD. Monday or Tuesday, any day. Monday.
Wednesday.
I have filed one additional affidavit in item number 18, my lord, that I may be allowed to call.
Please, the Lordship, I'd like first with regard to the eviction matter, Lordship.
Hmm?
With regard to the eviction matter that Lordship had heard day before yesterday, Lordship, that order is not yet online and today is the eviction.
And they will do it, I suppose. I have made, everything is ready, I think. I have asked. Get it now.
Documents and listing.
Listing. Okay. Friday. Friday is closed, na? Okay. On 21st.
Lordship, in item number 37 and 38, I filed affidavit in opposition. May I be permitted to bring those on record? Obliged. On Monday.
Son.
Please, Lordship. My lord, I beg to mention item number 21, Lordship. There is some subsequent development, Lordship. Want to bring it on record, Lordship. I have taken consent from the state.
See, when the matter is taken, you have to file affidavit, we'll see.
Please, your Lordship, item number 36 and 37, we have filed affidavit in reply to the petitioner's side. Like,
Please, Lord. I am taking for listing admission. It will come in admissions. Filleting has been completed, Lordship.
28.
High levels.
for motion item number 1.
Affidavit is filed here.
You have to file an additional affidavit. Did you file?
Filed on 13/8, your Lord. Not in record, your Lord.
Is the matter again on 21st of August. Appearing on behalf of petitioner submits that an additional affidavit has been filed. However, same is not on record. This is the matter on 21.
Yes.
Item 2.
Yes.
Lordship, just sometimes I do. Affidavit is not there.
I've asked you to find out under what provision this will happen, isn't that?
Extra copy do. You can speak very good. Comment upon it.
You paid this money only recently.
2 copies are there. Recently, they increased the amount that I have paid. And
You
earlier
paid
they-
this money recently only.
two receipts was there. Lordship.
Then,
One receipt I had paid in 2022,
and
23. And the latest one I have paid this.
this one is only down. How much is the land?
The total land is, Lordship, around six figures, altogether 17 figures. And the revenue I had paid in respect of 6 figures. Earlier, it was 500 per figure, and recently the authority has increased.
17 bigha, you have paid 1375.
That in respect of 6 figures I have paid. 2 owners are there,
Land is the same in both.
and the dark number is different, Lordship, 17. Dark number is different. Patta number is different.
Where is that act for conversion? That day I was looking into it. There's an act for conversion, no? From agricultural land to this. It cannot be done on its own basis. There's an act for reclassification of agricultural land to commercial. 2023.
I have a copy of this.
Yes, give it to me. Yes, government, you don't know anything. Just no, last time, Mr. Modunda, I put to you a specific question as to whether the land in question has been used for the last 10 years. Not as an agricultural land, because if you see 4, such land which is recorded as agricultural land but have been unfit for agricultural purpose or where there has been no agricultural activity for at least 10 years preceding the date of application for permission shall only be reclassified or so and so. No agricultural land during the 10 years preceding the date of year shall be reclassified as transferred for non-agricultural by the Deputy Commissioner without the prior approval of the state government in the Revenue Department. Now, where is your statement to the effect that for the last 10 years, it has not been used for agricultural purposes? Not fit for agriculture. Because without that, it cannot happen.
Yes, yes.
First.
Right.
Secondly, the circle, in this case, it is only a certificate being issued by or a report being given by the circle officer. The Deputy Commissioner has not done it till now. Then, on what
But if
basis this
the-
court should
the-
at all pass any order to that effect? Declare a nature of the acquired land for the as industrial instead of agricultural. How can this court do that?
But if the annexer, this annexer A and the annexer C, page 15.
Yes, this is given by the circle officer, but circle officer has no business power to do that.
I'm coming, Lord.
Yes.
These 2 documents are admitted and undisputed. These 2 documents issued by the one document is issued by the circle officer, whereby he has stated that land is not fit for agricultural. Presently, it is a commercial land, that is industrial land. And the page number. 15
But at present, commercial and not fit for agriculture. But from when? It has to be more than 10 years.
It is the issue is that when the land shall be reclassified, the authority has to follow the certain procedure, right? The land has to remain 10 years unused, that is, shall not be used for the purpose of agriculture. And when a citizen shall make an application for reclassification of the land, the authority shall verify, because they are the record custodian of the records. they will verify the relevant records, whether the land has been used or not. And obviously, they have verified the relevant records. Thereafter, they have issued the certificates. And second,
No. Does it say for the last 10 years it has been not used for agriculture? Those certificate.
how if it is used for the agricultural land, the circle officer may not say that the land is not fit for agriculture, presently commercial. Lordship, the categorically the word used commercial. That is, when the word has been used commercial, it is implied that the nature and character of the land has been reclassified.
No.
Lordship,
He has no business to say that.
Lordship may peruse the, if Lordship, I'm trying to satisfy the court.
And in the meantime, 3D has already happened. It is not going to help you.
Lordship, I'll address all the issues.
As of now, tell me, once 3D has already happened, till date there is not any document by which the Deputy Commissioner has classified as an industrial or commercial. Listen, it has not been done. So under such circumstances, the land is already vested upon the state. Who are you now to question this at present?
Yes. That is the Lordship, the two different issues. First, Lordship,
No. That is the most pertinent issue.
Lordship may peruse the NH Act. Section NH Act, I have a case that is I am submitting. Section 3G4 of the NH Act says that. So I am reading out the entire portion, so picture will be more tangible. Section 3G, determination of amount payable as compensation. Where any land is acquired under this act, there shall be paid an amount which shall be determined by an order of the competent authority. Where the right of user or any right in nature of the easement on any land is acquired under this act, there shall be paid an amount to the owner and any other person whose right of the enjoyment in that land has been affected in any manner whatsoever by reason of such acquisition, an amount calculated at 10% of the amount determined under the subsection 1 for that. Clause 3, before proceeding to determine the amount.
Mr. Mazumdar, these are beyond the.
Lordship, yes, I'm.
No, kindly come to the. If, as on the date on which the notification, there is a classification being made that this land in question is a industrial land or a commercial land, and then you are entitled to compensation as a commercial land. Okay. Now, in a case where because by virtue of 3D, the land vests upon the central government.
Central government, right.
Okay. Now, this land has already vested upon the central government, and till date, the authority, that is the Deputy Commissioner, have not yet taken any decision. There is no certificate given by the Deputy Commissioner to that effect that this land is a commercial land. It is being given by, it's only a provisional report being given in the year 2019 by the circle officer that this is not fit for agriculture. But it does not say that that for the last 10 years or so, this land has not been used for agriculture. So under such circumstances, section 4.1 would not apply. Now, in view of that, can you apply 4.2? For doing 4.2, you have to get the permission from the Revenue Department, which also as of now you don't have. In the meantime, the land already vests in the central government. Now, what is your locus? There.
Land is, these are the factual statement. I am not opposing. Lordship is absolutely correct. The land is best.
Mr. Mazumdar, I may give you an advice, although it is not my duty to do so. I would, if I have to pass an order, I am going to dismiss your petition holding these as of now. If you try your luck out there and say that you are entitled to a higher compensation in terms that file a sub application under 3G5, you can very well go ahead. Which one? But the moment I decide anything, you are gone. Make it very clear. I am giving you a good option. Either of those. Either I dismiss the petition, holding you as of now, you don't have the locus. Second is, you may very well go ahead before the arbitrator, say that this is my land out here, which is a commercial land, and so, this is the certificate. It may prevail upon the arbitrator, yes, this is a commercial land. He may do it, and his order would be binding. But for this court to say, in view of the provisions of this Act of 2015, very difficult, and you lose your locus. Which one? Tell me.
Yes, I'll have an opportunity to deduce the evidence in front of the arbitrator. That will be good for me.
You do approach the
Because is that necessary?
due evidence. Get it for the last 10 years, because this document doesn't show. Because the provisional certificate, if we just take it also, it could only date back to 5 years. And if it is 5 years, because it is of 2019, if it is 5 years. Now understood, another very interesting thing, now the land vests upon the state in view of the notification under 3D. Why you are paying the land revenue, get the money back? Because
Yes,
land
yes,
has
also
all,
this observation, they have accepted the money.
they have accepted, get the money back. Why are you taking that money? As of now, the land has vested upon the state. So they could not have accepted the land revenue. More particularly on 12/8/2000 year, just 3 days back.
Another point is there that the section 3G4, obviously I'll accept the advice of the Honorable Court that it says that after publishing the 3D notification, any person who has interest or right on the land, he may make a representation to the concerned authority, and they are legally bound to dispose the same before determination of the compensation. Accordingly, that representation I have made term of the section, but no decision is taken on my representation. So they may take a call on my.
If they don't do it, then the next option lies. Approach the authority, make a reference. Next option. They don't do it and they give you a compensation, you accept it under protest and do it.
Worship this,
Because you see, this is a self-contained court. For this court to interfere at this stage would not be proper. There is a particular procedure. I agree by that. Very well, you can file 34. You can file whatever may be. But why should this court at this stage interfere with all these things? 226 is not.
Worship, I'll approach to the arbitrator, just my humble submission and prayer is that that observation may be given that the land is now vested with the union government. Already they have taken ownership right. So under that circumstances, how can the revenue authority accept the revenue from me? So it may be refunded.
I will like.
Otherwise, I'll lose 34,000.
Yes, any help from any of the government councils? No. And appears for government council. But Mr.
Abject.
Ted Majumdar, the learned counsel, appearing on behalf of and appears on behalf of the respondent. The instant petition has been filed by the petitioner, taking a direction, taking a declaration that the land which have been acquired by the by the, who has acquired this? By the central government.
National Highway Authority.
By the central government. For building bracket, widening oblique four laning, etc., comma, maintenance, comma, management and operation of NH 306. Of the petitions by the central government, by the notification dated 16/10/2023, for building bracket widening oblique four laning, etc., maintenance, management and operation of NH 306 in the stretch of land from in the 306 is a commercial land, which however have been mentioned in the notification under section 3D of the National Highways Act 1956 as an agricultural land. Under such circumstances, the petitioner seeks a declaration that the land of the petitioner should be declared as commercial land. In that regard, the petitioner had also submitted a representation on 31/5/2024 before the before the Deputy Commissioner, District Commissioner, Kachar, pertaining to their lands. However, the same have not been duly taken into consideration by the respondent authorities. First, for understanding the dispute involved in the instant proceedings, it is seen that the petitioners herein claim that the petitioner number 1 is the owner and possessor of a plot of various plots of land at measuring 15 bighas, 11 kotha, 15 chataks, covered by dark number 17, 18, 20, 12, 14, and 16 of second RS patta number 8, 12, 13, and 15, situated at Moza, Kazidhar, Dahar, part Roman 3, Porgana, Bonraj, Pust. The petitioner number 2 also has a plot of land, various plots of land at measuring 17 bighas, 19 chataks, 4 kotha, 19 kotha, 4 chataks, 10 gondas, covered by dark number 17, 18, 20, 12, 14, and 16 of the second RS patta number 8, 12, 13, and 15. It is seen from the records that on 7th of August 2019, 2 certificates were issued by the Circle Officer Sonai Revenue Circle, stating inter alia that the lands of the petitioners, though, are classified as Sailura, Tora, Chara, Asaraua, Asraura, Bari, etc., but at present commercial and not fit for agriculture. In addition to that, the documents also show that the petitioner number 2 who is the wife of the petitioner number 1 have been granted the permission to carry on 14th of September 2022 to establish a brick industry in the name and style of MS Priya Brick Industry. Thereupon, on 14/3/2023, a notification was issued under Section 3 Capital A of the National Highways Act 1956 for acquisition of various plots of land, including the land belonging to the petitioners, including certain portions of land, not the entire land, certain portions of land belonging to both the petitioners. In both the notification, pursuant thereto, subsequent thereto, it is also seen that on 16/10/2023, the 3D notification has been issued. Notification under the Act of 1956 have been issued, whereby the said portion of land which have been acquired to vested upon the central government. The petitioners thereupon submitted a representation stating inter alia that the lands in question have been shown as agricultural land, but the said lands have been used only for commercial purposes. And in that regard, the certificate has also been issued by the circle officer on 7/8/2019. And under such circumstances, requested the competent authority to make payment of the compensation to the petitioner, taking on the basis that the land in question is a commercial land. However, as nothing transpired thereupon, the petitioner approached this court by filing the instant writ petition. This court, when the matter was listed before this court on 5/8/26/7/2024, as well as on 5/8/2024, this court had put a specific query upon the learned counsel appearing on behalf of the petitioner as to whether the said whether any authority have categorically classified the land of the petitioners as commercial land. To that, the learned counsel appearing on behalf of the petitioner have filed an additional affidavit bringing wherein it has been stated inter alia that the respondent authorities have always treated the lands of the petition, respondent revenue authorities have always treated the lands of the petitioners as commercial. And this aspect could be seen from the fact that the land, the fact that revenue which commensurate with commercial lands have been taken from the petitioner rather than agricultural lands. This court had duly perused the said affidavit wherein the land revenue receipts have been enclosed. Annexure B to the said affidavit shows is in relation to our land revenue receipt dated 12/8/2024, wherein it is being seen that from the petitioner number 2, an amount of rupees 34,131.25 have been taken against the lands belonging to the petitioner number 2. This court, taking into account the above, have put a specific query upon the learned counsel appearing on behalf of the petitioner as to under what circumstances the respondent authorities are still taking the revenue, respondent revenue authorities are taking the revenue from the petitioners if the land in question have already been acquired. The learned counsel appearing on behalf of the petitioner submits that the entire land of the petitioner number 2 have not been acquired. It is only a portion thereof. It is under such circumstances not clear as to whether the said Annexure B to the additional affidavit is in respect to the land which have been acquired or not, or is in respect to the remaining land. Be it as it may, this court have duly taken note of section 3D, 3G of the National Highways Act 1956. Which stipulates that upon the acquisition of the land in question, compensation is to be paid on the amount determined by the competent authority. The petitioner herein had submitted a representation on 31/5/2024. It is not known as to whether the said representation have been duly redressed or not, taking into consideration that redressed or not. However, if the said representation is not being redressed to, and the compensation have been already finalized by the respondent authorities, this court is of the opinion that the petitioner be given the liberty that in opinion that the interest of justice would be met, thereby granting the liberty to the petitioner to submit an application to the competent authority, that is the respondent number 3, as regards the inadequacy of the compensation in terms with section 3G5, and on such representation being submitted, the respondent number 3 is directed to refer the matter to the arbitrator for deciding as to whether the compensation so paid to the petitioners are inadequate. The learned counsel for the petitioner submitted that at present, the Special Secretary to the Government of Assam, one Mr. Ashok Kumar Burman, is the arbitrator nominated by the central government. Taking into account the above, this court therefore disposes of the instant petition, thereby directing the respondent number 3 to refer the dispute to the nominated arbitrator. Nominated arbitrator by the central government within 30 days, subject to the petitioner submitting its representation within how many days? 15 days? Within 15 days from today. Within 30 days from today. It is however made clear that a petitioner would be at liberty to raise all such disputes so raised in the instant petition before the learned arbitrator, and insofar as inadequacy of the compensation.
If I may most humbly submit, my lord, the affidavit filed by the petitioner, the revenue receipt on which he seeks to place reliance on was not served upon the government advocate's office. Revenue is not a party, my lord, herein in the writ petition. He has filed that affidavit by serving a copy to the revenue department. It is not known the veracity of that piece of paper he seeks to place reliance on the basis of which he says his land should be.
No, madam, I have not dealt with that aspect of the matter. I only asked him how. Why? Because on 12/8, once the land has already been vested with the central government, how there can be payment?
Yes.
So he has given an answer to that effect that it is only a part of the land which has been acquired, because he had 17 bighas of land. Only a part, that is 0.3. 0.03.
Also,
The land which have been
that-
acquired.
That document, my lord, the veracity of that document will be.
I have nothing to say about that document. I have neither his land which have been acquired is
because revenue has
0.03.
been accepted by the, revenue has been accepted by the,
No, therefore
does.
it may have been, because you see the petitioner number 2 had 17 kathas of land, bighas,
Yes.
of which only 0.0339 hectares of land have been acquired, which comes to almost around 4 bighas, 5 bighas of land. So therefore, the remaining has been accepted. But he wants to show that whatever remaining has been accepted is also at the value of that.
This is an afterthought. After this is come in, my lord, this is an afterthought at best. He has not raised anything before the deputy commissioner prior to this writ petition.
No, he has given a
It is only
submission.
after the
No,
3D notification.
No, 3D, because of the fact that 3D shows that it is an agricultural land.
Yes.
Now, the authority, let the authority decide.
Yes.
I'm not saying anything.
Obliged. Okay.
Item 3.
Yes. What is this?
My lord, the respondent NHIPCL you know, initiated to construct a road budget from Silchar to Byron.
Follow the previous survey and line and acquisition.
We get objections, my lord, from the landholders
Alignment
on the proposed alignment. Accordingly, we filed our objection, my lord.
Where,
We are called for hearing, my lord. Your lord,
where you have filed your objection?
my lord. Page number 35.
Ah.
Annex 2, my lord.
Then this objection is against 3C notification. Where is the 3C notification? Where is the 3C notification?
The drawing is there, my Annex 1, my lord.
3D has happened, now you are asking this. How can this happen? What happened to 3C? You approach under 3C, saying that kindly don't acquire this portion of the land.
Fine.
Fantastic. Thereafter, they went ahead and did 3D.
My lord, our objections have been considered by them. And we are called for hearing. And we, my lord, presented our case in support of protection of the graveyard, my lord, saying that within the 16 kilometers radius, there is no other place to construct a new graveyard because it is a low-lying place and it is a flood-affected area. For several months together, the entire locality remains underwater. My lord. Then, my lord, your lordship may kindly see my lord, page 38, my lord. Page
Yes.
38, my lord. Then we were issued notice. Our name is at serial number 18. Samuddin Bodvi, my lord.
Then
With reference to the above, I am to inform you that the date of hearing has been fixed on 17/4/2023 at 11 AM on objection filed by you in connection with proposed construction of four laning Silchar Byronty Road. And accordingly, my lord, our hearing was held on 17/4, next page, my lord,
I've looked into then.
on hearing, my lord, hearing. And our case was referred, my lord, it says the objection petition may be forwarded to the NHIDCL for further necessary course of action in this
So
regard.
your land has been acquired.
My lord, no, my lord. We have been exempted.
Where?
Yes, next page, my lord. Next page 41, my lord.
Which one, where?
My lord. Then by this notification, Ministry of Road Transport and Highway notification, my lord.
Which one?
The plots of land, my lord, of this alignment, my lord, have been, my lord,
Exempted.
but our plot has been exempted. My lord.
How do you say so?
Kindly see, my lord. Page 47, my lord. Page 47.
Ah.
Above, my lord, Kashipur Part 2.
Huh?
Page 47. Above, my lord, village
Serial number?
Part 2.
Serial number?
Next page, my lord.
Page 47, serial number?
My lord, page 47. Next, now, my lord, you not may kindly turn to page 48.
Ah.
Survey number 224, 225.
224? Where 224 is? 124 is there.
The serial number, my lord.
124.
The serial number.
Ah.
And next column. The second column is the survey number.
Ah.
Plot number.
No.
224, 225. My lord. Then our
Where 224 is there?
page number 48, my lord.
Serial number 120. Again, so serial number. Why you are not mentioning the serial number? What is the problem with you?
Serial number 120, 121,
Ah,
225.
Yes. what
And
happened?
then, my lord, our plots are 228 and 229 of this revenue village. 228 and 229, my lord, have been exempted. That means our objections have been
Your land is where?
but our land is, my lord, 228 and 229.
Then?
So, my lord, we are very happy that our graveyard has been protected by the respondents. My lord.
Very well. Then?
But thereafter, my lord, under heavy political pressure, the competent authority, additional district commissioner, my lord, again, my lord, wanted to shift the alignment. And this, my lord, proposed shifting, my lord, is affecting our my lord, graveyard, my lord.
Where?
68.
58.
58.
Page 58 is a type copy of what document?
Page 58, my lord.
Is a type copy of which document?
Next page, my lord. Kashipur Part 2.
And what is this document?
Document, my lord, has been collected from the office of the
What is this document?
land acquisition. And
What does this document show?
here, my lord, these serial, my lord, plot numbers,
Ah.
228, 229 have been shown as being, my lord, acquired.
No, they will issue a 3D, then only they will acquire. Without the 3D, they cannot acquire.
Now, this is
On the basis of this, they cannot acquire.
then, my lord, having learned this, my lord, we again filed a representation, page 59 and exhibit 7, my lord.
Hmm.
Page 59 and exhibit 7, my lord. To the competent authority, land acquisition, NHIDCL, come additional deputy commissioner Kasar, saying, my lord, that to consider our case, to protect the 100-year-old, my lord, graveyard in the interest of public, my lord.
But as of now, they don't have 228, do they?
My lord,
Do they have 228?
228 and 229.
Village is what?
Kashipur Part 2, above,
Huh?
my lord. Kashipur Part 2,
Kasipur Part 2.
my lord. Serial number 93 to 28, 94 to 29. 29 graveyard and 228 each, it has been for non-agricultural, but now it is also being used for burial purpose.
Where in this 3D notification, any land of Kasipur Part 2 have been acquired?
Page, my lord, then we have to come back page to page 41, my lord.
Where? No. Where is Kasipur Part 1 or Part 2 in that 3D notification?
At page 47, my lord.
Huh?
At page 47.
Where?
Page 47.
Kasipur Part 2.
Yes, my lord. Village Kashipur Part 2. It starts from serial number 96 and it goes on and up to, my lord, serial number 121. That is plot number 225. And next they have gone, my lord, to 429. So we were exempted, my lord, initially.
Yes, NHI. What is your stand?
That's situation, my lord.
Huh?
They have annexed.
Hmm.
Is this a part of the?
No, Annexus 6, forget about that. I'm not concerned. Their apprehension is there was initially a plan to take to their dark numbers 220,
29.
228 and 229. Then they had raised an objection, and pursuant to the objection, you came up with a 3D notification which shows that 228 and 229 is not there. Their apprehension is now, at the behest of somebody else, you are going to again take over 228 and 229 on the basis of Annexus 6. But Annexus 6 document, I don't understand anything, head or tail. What is this? This has no value.
Access 6 page 58. Proceed. What is this document from?
What document is that?
Okay, put it as.
Understanding that we are being victimized, my lord, we again filed this another 7 representation before the for consideration.
What is this?
Public, my lord.
Fine.
Yes, man, get your instructions.
Lordship.
7 days notice. Get your no stay.
Yes.
Notice making it returnable on 28/8/2024. Union? No. No union. It's our Bora.
Lordship.
Here's on behalf of the respondent number 2,
3, 4, 5.
4, and 5. And 6. 6 also, na?
6 also.
And PWD, what is PWD doing? Once you make NHAI, why you are making PWD?
Earlier one case, my lord, we had made PWD. as-
Huh?
Other case, my lord, we have made PWD.
Another case, 10 years back, another case you have made from PWD. Does it make any sense? On one hand, you categorically say it's the national highway who is doing it. And on the other hand, you are saying PWD. Why you are making the PWD a party?
Kindly be not treated, my lord.
Also.
H. Sharma, Mr. H. Sharma appears on behalf of the respondent numbers 9 to 14.
10, 13, 14,
9, 10,
13, 11, 12 PWD.
13, and 14.
7 and 12 may kindly be, my lord, deleted, my lord.
So and so appears on behalf of the revenue here. Taking into account that the PWD has no role to play in the instant acquisition proceedings, this court is not inclined to issue notice upon the respondent number.
7,
My goodness, then there is no state of Assam.
the version is there, my lord.
How, where?
Deputy Commissioner is there.
Deputy Commissioner will represent the state of Assam. My goodness.
But then state is not there, my lord.
Now, without state, you are making the other persons a party. Is not inclined to issue notice upon the 7, 11, and 12. As the respondent, as the respondent numbers, the council appearing on behalf to 6 and 8, 9, 10, 13, and 14 are duly represented. Extra copies of the writ petition be served during the course. The case of the petitioner herein is that, who are you?
President of the, my lord, Graveyard Protection Committee.
What?
And this does not belong. Kashipur Graveyard Protection Committee, my lord.
Have you been given the authorization to file on their behalf? Huh? Where? Where?
Half of the committee, my lord,
No,
I have stated.
no, because what will happen tomorrow if I dismiss, it will impact upon them. You have no business.
Here I am speaking
No,
on
no,
my
no.
behalf, as well as on behalf of.
No, nothing doing.
Yes.
The instant writ petition has been filed. Issue notice no. So and so appears on so and so or so and so. PWD the lump sum did dismiss column did so and so. Union none appears for union too. The petitioner herein claims to be the president of Kasipur Part 2 Community Graveyard Protection Committee. And has approached this court alleging apprehension that the respondent authorities, though have not included the land of tag numbers 228 and 229 of Patta number 13 of Kasipur Part 2, Moja under Barakpur Pargana of Silchar Revenue Circle in the district of Silchar within the ambit of the notification number 3D is there under issued under section 3D of the National Highways Act 1956, dated 28/12/2023. But there is a move to include the lands of the petitioner within the ambit of to acquire the said land, a land of this Kasipur Part 2 Community Graveyard Protection. Belongs to whom the land? Whom? The that the land, that the said land would be acquired by the respondent NHI authorities. This court have duly taken note of that the petitioners have neither filed any document showing, petitioner has not filed any document showing that that the petitioner herein has been duly authorized by the owner of, by the patadar in respect of dag number 228 and 229 of pata number 13 to approach this court, nor have produced any authorization, any document to show who is the owner of the said land by producing the record of rights, etc. Under such circumstances, without going into the merits of the instant writ petition on the ground of locus standi, this court dismisses the instant writ petition as on account of the failure of the petitioner to produce any document in that regard. Be that as it may, the dismissal of the instant writ petition shall not preclude the patadars of dag number 228 and 229 of pata number 13 of Kasipur Part 2 Moza under Barakpur Pargana of Silchar Revenue Circle in the district of Kachar to approach this court.
Item 4.
And Mr. Counsel, you are again going to, Mr. Counsel, you are again going to come. I've given the liberty. Welcome. But then next time, don't make PWD. Then don't make State of Assam represented by PWD. And not by the Deputy Commissioner also. Yes. What is this such a big petition?
Petition orders.
Huh?
It's challenging with
Challenging?
mutation orders. That has not been considered.
Consider the statutory appeals dated so and so filed by the petitioner before the district and praying to cancel the mutation issued by the so and so. What? What is your prayer? What is your prayer? What are you challenging? There was some mutation order. You filed an appeal.
That has
Before-
not been,
Huh?
the appeals has not been considered till later. That is why I'm before your lordship.
Why this is environment degradation aspect? So much of papers have been used.
All the even appeals I have annexed.
You want this appeal has not been disposed of. That's all.
Yes, sir.
Appeal number?
Lordship, that appeal number has not been given. We have
What?
approached, appeal number has not.
You
been
filed
given.
in the year 2021, you
Nothing
don't
has
know.
been done. Nothing has been done till date. Only a file number, PK.44/2021 was given.
B?
PK.44/2021 was given by the petitioner.
Where?
I have mentioned it in my petition, lordship.
How many mutation orders you are checking?
11 petition orders.
Huh?
11 petition.
and one appeal,
11 appeals. Only one petition filed.
but one writ petition. Then why didn't you approach the revenue authority? Revenue board? 151? If this is not being done, why you not approaching that? You don't have any numbers. Revenue board can very well take up. Taking that we have asked the deputy commissioner to do it, the deputy commissioner is not doing it. Do something. Anyways, Mr. Sharma, you get your instructions next week. List. Heard no, issue notice, making it returnable on 22nd of August 2024. Mr. H. Sharma,
Lordship is making it returnable on
22nd of August 2020.
22nd.
Where is this?
It's from board. That is
Corpeta, there is, I think, no cellular network, no?
not because of that.
Then just give a call. What is this? Why you are not disposing of? Nothing more than I'm not asking anything. I want to know what is the number. Then the moment it is given, then I'll pass a direction. Dispose it of. That's the only order which can be passed. Nothing more than that. Only verification as to whether the appeals have been filed. Nothing more than that. Ms. So-and-so appears on behalf of the respondent number 1 and 2. 2.
Hello, Google it.
This is the one wrong logic.
Para 9.
Take up a legal. Department of Land Record.
Here you appear. Anyways, he's not going to post it. 1 and 2. Mr. AI appears for the respondent number 3, 4, and 5. Taking into account the respondent numbers 1 to 5 are duly represented, the extra copies of the writ petition be served upon them during the course of the day. The petitioner herein is aggrieved by the inaction on the part of the respondent number 2, 3, in deciding the statutory appeals so filed against the various mutation orders which have been challenged separately by the petitioner. Full stop. This court had inquired with the learned counsel appearing on behalf of the petitioner as to what number has been assigned to the said statutory appeal so filed. The learned, however, full stop. The learned counsel, however, submitted that there is no number assigned except what receipt? Receipt is what?
Page number 12. BK.44/2021.
Except giving page number
12.
12. Except, except a file number is being given being BK.44/2021. The only grievance of the petitioner is the respondent number 3 have not taken up those appeals for consideration and as such have sought for an appropriate writ direction and order. Mr. H. Sharma shall, in the learned counsel appearing on behalf of the respondent number 3, 4, and 5, shall apprise this court on the returnable date as to whether the appeals have been duly received by the office of the district commissioner, Borpeta, and what is the present status of this, and if so, what is the present status of the said appeals?
Receipt copy. I have submitted the receipt copy.
Okay, let him come up.
Okay.
Once he says yes, then only I pass.
Five.
But this is environment degradation. Yes, what is this? Mr. Mishra, what is this? Cancellation.
Allowed to withdraw this petition with the liberty to file a case, my lord. I have incorrectly described the nature of business carried out by the petitioner, my lord.
Huh?
describe the nature of business carried out by the petitioner, my lord. So I may be allowed to withdraw with liberty to file a fresh, my lord. In paragraph
Nature of the business.
carried out by the petitioner, my lord. I have wrongly described it. Yes.
The learned counsel appearing on behalf of the petitioner submits that there are certain formal defects in the instant writ petition as regards the description of the business of the petitioner. And as such, he submits that he may be permitted to withdraw the instant writ petition with a liberty to file. First of taking into account the above, the instant writ petition stands closed on withdrawal. So, however, liberty is given to the petitioner to refile by removing those formal defects.
6. This is with regard to challenge of notification 56, my lord.
What?
Challenge of notification number 56, which your lordship has fixed it on 21st of August.
Okay. সেইটো সেই অৰ্ডাৰটো দি দিব সেইটো যে সিদিনা লম্বা অৰ্ডাৰটো দি দিছে এছমিছৰ
Yes, lordship.
21st.
Lord.
Get your affidavits filed, both,
Yes, we are preparing. So additional effort we are.
because that earlier affidavit is going to finish it.
Yes, lord.
Come up with a better
We
affidavit.
are filing the better.
সেইটো একে অৰ্ডাৰটো দি 21st of fix.
Yes, we are filing.
And government also.
7.
A tag belong with সেইটো লিখিব না last line টো লিখিব is this matter on so and so along with so and so. ওপৰৰ এইখিনি আৰু কৈছে কি আহিব সেইটো পুৰা এইটো অৰ্ডাৰটো মাৰিব. Yes, what is this?
The incident note at
Impugn notice dated 22/7/2024. Where is that? Page 67. What is this notice? Notify all members of so and so that a general meeting will be held on 17/8/2023. This notice was issued when?
7/2024 launch.
Then?
And actually these two clauses, lordship, clause number B and clause number J.
Huh?
Clause number B and clause number J are arbitrary in nature. That but lordship, the notice has been issued by the chairmanship. It's according to the chairmanship has already been seized. And that
Have been issued by whom? It's also issued by the secretary also. Then secretary period, how will it end? Secretary period doesn't end, does it? No? Then notice proper. No case. Dismiss. And the meeting is tomorrow. Fantastic. So we dismiss it right away.
I take your lordship to page page 60.
You have any problem, file election petition. No business of this notice being cancelled. Hello, dismiss.
Lordship may take it on.
Monday it is going to become infructuous. Isn't it? Meeting is on tomorrow. No, madam, meeting is tomorrow. Meeting is tomorrow. So under such circumstances, why should this court?
Earlier board of chairman who has whose chairmanship already ceased lordship and two writ petition has been preferred before this honorable court. I'm taking lordships to page 64 lordship, the order passed by the registered lordship, wherein it says lordship why the grievance of the petitioner has been dismissed. I'm pressing that lordship. May I read the contents, lordship? In pursuance of the petition dated so and so submitted by Mofijul Haq that the present petitioner's lordship as action watching for HM on so and so. Taken the meeting Uttar Bagwari Sambai Samiti legislated. Executive committee meeting dated so and so under the chairmanship of Atwar Bhuiya. His a hearing was held on 27/5/2024 at so and so. The hearing was attended by so and so and Borpeta Atwar Bhuiya so and so. so and so. Had petitioners and the respondents peruse the documents submitted by both the parties and also peruse the order of the Honorable Guwahati High Court dated 2/4/2024 in WPC 69 7/4 of 2000. As the matter is submitted before this Honorable Court, hence the matter would not be subject to the outcome of WPC number 24 2413 of 2023. The petition.
No, madam, should I dismiss? No, madam, I'm not going to hear all this thing. I'm going to dismiss it right away. Think. By tomorrow, get ready to file an appeal. You get the order immediately.
In that case, Lordship may fix it on.
No. This time I don't fix this matter because again, today, again, tomorrow is the same thing.
I just.
Better if you have any problem, raise an issue by way of an election petition within 3 days. Do that. Because you see, the law is very clear. Once the election process has started, the court should not interfere. And right from 1951, Punaswamy, that is the strand of judgments. Now you have an election proceedings. Section 27 is there. You file an appeal representation within 3 days from the date of announcement of the result. Go there.
For a moment, Lordship, these two clauses, let me place these two clauses, which debars the members to participate even, Lordship. I'm placing that, Lordship. Page 67, Lordship. Whether that is arbitrary or not, Lordship has to approve.
Let's see who are who. The
The
board of directors will
Yes, sir,
which clauses?
67 of the impugn notice, which are.
Which clauses you are saying?
The impugn notice.
B. For
For the-
position of the buyer, a receipt for deposit of the nomination fee must be attached to the nomination paper. This applies to general category, reserved category, so-and-so, women. Additionally, candidates must have a photograph of so-and-so. The nomination fee will not be refunded to the candidates whose contest the election or withdraw their nomination. Okay, then what is bad?
Lordship, that, Lordship, because in case I want to withdraw my nomination, Lordship, this amount should be refunded.
Are you contesting? Are you contesting? Are you contesting? No, I am asking you, madam, are you contesting?
The clauses has, and that apart clause number J, Lordship. Lordship, J, Lordship. Only those shareholders who have attended at least 2 annual general meeting in the past 5 years will be eligible to submit a nomination papers, Lordship. So these divers, many of the members to even participate, Lordship. Under this circumstance, it is very arbitrary, Lordship, in nature, Lordship. So I'll satisfy in the next date. Only I'm not asking for any interim stay or anything, Lordship.
Some cooperative society. Madam, kindly come to this provision.
Rule 12, Your Lordship.
Huh?
Rule 12, Your Lordship, of the elections in regard to this amount of 5,000. Assam Cooperative Society Election Rules 2000.
A nomination paper shall accompany a receipt of non-refundable nomination fee as shown below. State, urban, 5,000 each, district level societies, wholesale cooperative society. What to do? Challenge this rule. And the other is, it is already here. That's the provision, no, Mr. Rajkumar, which is that provision out there that a person cannot be a 30, there is a, what you call, disqualification. What is that? 30? Qualification, eligibility, yeah.
Condition of membership.
Rule 27 is there.
42, 42, section 42. You have not read the book. Without reading the book, you have filed this writ petition. See section 42.
Of this matter on,
Dismiss with cost now.
I
You
will be
have-
allowed.
With cost. Absolutely. Encourages writ petitions.
I will be allowed to withdraw.
Is T. Somdala, we heard Mr. T. Somdala, learned counsel appearing on behalf of the petitioner.
That's
Mr.
10-1 to 4.
V. Rajkwana
Viraj.
appears on behalf of the Corporation Department. The instant writ petition has been filed challenging the notice dated 22/7/2024. Whereby the general meeting of Upper Baguri Bari Cooperative Society Limited has been called and notice dated so and so, whereby the general meeting of AIA have been notified to be held on 17/8/2024 from 10 a.m. First, the petitioner herein have assailed the instant notice on in view of clause B and J of the said notice of the note to the said notice. First, taking into account section 40(2) of the Assam Cooperative Societies Act 2007 and Rule 12 na,
12, yeah.
of the Assam Cooperative Societies Election Rules 2019. The learned counsel appearing on behalf of the petitioner submits that she may be permitted to withdraw the instant. Accordingly, the writ petition stands dismissed.
Great.
Supplementary item 51.
Yes, did you find out?
Yes.
226 or that? Done.
There is judgment of the division judge, division bench.
And there are two
I have
Gave me
given,
2 copies of the
I
same.
have given one.
I have this one given
Both belong to you.
four.
By mistake,
Very-
one has. One I would like it to be.
That's good, but both the judgments are on different facts.
What different? As far as the judgment of the division bench, I was a party to that judgment. It has been relied upon by my lunch friend. That judgment was on the peculiar facts of that case because
That is section 17.
section 17 and the petition was pending before this court. So in view of the submission that this honorable court did not want to enter.
No,
that
the
is the-
power under a there. Petition is 4. Charge the period of limitation under 227. 7 would be difficult.
But if your lordship sees the judgment of Justice Surana, that is that.
Justice Surana there, but the question is he went on aspect of urgency.
Yes.
And said that once the judgment, the case is reserved for final orders, you cannot. But all said and done, in this case, it was fixed for written statement, he failed and it was happened on 19/6. And the proceedings are still there. So that is how Justice Surana's judgment is there. But the question is as to whether this court can exercise 227 while enlarging, no. That this court cannot enlarge. This court can, however, enlarge under 226.
But Lord, the allied chemicals judgment which I have submitted, that was though against a final.
No. 226. Allied chemicals is on a different point. Allied chemicals was the point where our case had this person concerned that he did not get an opportunity to cross-examine during the proceeding. Matter went on. Matter judgment delivered. Appeal was not filed. After 10 months, he comes up and files a petition. Then look here. No, kindly set aside this. This is on the basic principle that if you have a period of limitation right in a statute, you can't circumvent that by 226. It's on another thing. But if it is a case of failure of natural justice for reasons which is beyond the control, just for example, yes, if it is beyond the control, then can you say that the provision out there is such that you cannot? Just for example, a person could not. That he has made a case or not, that is another aspect of the matter. But whether the facts are that the person could not have given it.
Act of God circumstance.
Act of God. COVID. Let's take the case of a COVID.
There are two aspects of
If it
it.
was a
One
COVID.
is not under section 19(5), if the DRT allows, even for 45 days, that is the 15-day period, then it has to record exceptional circumstances. Whether the application that they have filed, my lord, that discloses any exceptional circumstances. Secondly,
That is another thing on
that is
facts.
on the merits of the issue.
On the merits of the issue.
Now,
But
going-
whether the DRT has if the DRT does not have the power,
Yes.
this court can't confer the power. But this court can exercise 226 in the interest of justice
Yes.
on the basis of Article
But
2.
that, my lord, would be in a rarest of rare act of God situation. Otherwise, my lord, it would.
But not 227.
that
227 cannot be done because if you go for 227, it will have this court's power is much limited.
26 also,
But
my lord.
only thing is, one thing, what is the what is the stage of the DRT?
On Monday, my lord, for hearing. Monday.
We state till come up on 31st. Let us see what it is his case. We dispose it on the basis of the merits as to could it be done.
I'll bring the judgments on the merits aspect also.
Merits on the merits, how much it is, because this court may not like it.
So, today I brought only on that maintainability.
But these two judgments is on different aspect. But what I think, 227 cannot, because if it is to be extended, yes, if there is an illegality, it's a different thing. But what do you call the DRT went on the question that they have no power. So then it is the question if they don't have a power, but it is a case where the natural justice is at stake. Then obviously this court under 226 can. Eh?
That's the sort of preliminary power which this court has.
That power is there. Otherwise, that provision becomes bad. In fact, a very beautiful word in that if you read the judgment of the Supreme Court in Menoka Gandhi, it says that certain acts may not prescribe a notice or anything. But the courts, while interpreting those provisions, infuse the requirement of a notice to make it in terms with Article 21.
Rule 18, I would suppose perhaps the Assam Land and Revenue.
That I have imported here also in Rule 18 judgment, I have done it. But this is what it is. The Act may not, but you need to infuse it. Maybe the DRT may not. But if it is a strict case of a case being made out, but it has to be in a very rare case because it cannot be open. It can't, because once I do here, it would be amount to opening up opening floodgates. So it has to be limited in the, it has to be seen that he could not have. Because I can't also, I don't think I can direct the DRT to decide. Can I?
That would amount to
Because
setting aside of
this
that.
would then be directing the DRT to exercise a power which
It
the
does not.
Act does not. But let's have it on 21st.
I'll bring the judgments on the merits part.
Notice. Issue notice. Making it returnable on, we'll have it on 20. Can we have it on 20 or 22nd? Because this may
22nd.
Huh?
20th is okay.
20 or 27th. Because 21st I got many matters.
27th.
Huh?
27th.
27. Issue notice making it returnable on 27/8/2024. Mr. A. Ganguly appears on behalf of the respondent number 1 and 2. As the respondents are duly repeated, extra copies of the petition be served upon him during the course of the day. The case of the petitioner herein is that the petitioner have challenged an order dated 14/6/2024 passed by the learned Debt Recovery Tribunal Guwahati in OA number 79/2024, whereby the learned tribunal have rejected the right of the petitioner. I have rejected the prayer of the petitioner, taking time for filing the written statement come evidence on affidavit. On the ground that the period prescribed in section what is that section? 19 what?
Subsection 5.
Huh?
19 subsection 5.
19.5 of the recovery of debts, the name Recovery of
Debts and Bankruptcy Act.
and Bankruptcy Act 1993. Is over. This court have duly perused the said provision, and a perusal thereof shows that there is no jurisdiction shows that prima facie the Debt Recovery Tribunal does not have a jurisdiction to extend the period beyond the additional 15 days as prescribed, as stated, as mentioned, as stipulated in the proviso to section 19.5. This is the proviso, no?
Good.
Under such circumstances, a question duly arises as to whether in a case where it was absolutely beyond the control of the petitioner to file the written statement within the time stipulated in the in section 19.5 of the Act of 1993. This court, under Article 2 to 6 of the Constitution, can direct the acceptance of the written statement. This aspect would require a further deliberation. It has also been brought to the notice of this court that the next date is fixed before the learned debt recovery tribunal is on 19/8/2024 for hearing. Under such circumstances, this court is of the opinion that allowing the proceedings at this stage, when the said question is being adjudicated upon, it would be an abuse of the process. Accordingly, this court states OA number 79 oblique, the further proceedings of OA number 79 oblique 2024 till 27/8/2024. Attempt shall be made to dispose of the petition on the next date. The matter be listed at the top of the list. We'll dispose it of only that aspect. We'll just have a look. I don't think he has a case, but this is a point which needs to be answered. What is it?
Hearing will land, and usually I have taken stay on the last milad by 3 times by respect. And last order, Lojina court's order milad, 29/7/24, I could not repair and the notice I escaped. So, only time today I take by stay by today itself. By respect. Remember, test milad on 29/7/24. We have to take step by respect again.
What are you challenging? What are you challenging?
Any challenge, I have some land milad, and that land milad, one of my brother wants for partition. And in partition milad, we are not properly milad given notice and.
What's, how should they give with Vata and Horai? Huh? You have that, page 16.
I,
You have been given a notice. Why you are not appearing?
but now we will appear milad.
Then, what is this type of repetitions? And you have been pending this matter before this court. Oh. And what is your prayer?
Milad too, yeah.
Read the prayer, read the prayer. We need something of light
Please.
amusement during the course of the proceeding. Read it. Directing to make the partition of the land situated at so-and-so in the name of the petitioner without proper opportunity of hearing. Huh? You want a partition to be made without proper opportunity of hearing to the petitioner. What is your prayer? Read it.
Direction should not be issued directing the respondent to make partition of the land situated in Dock number so lot, part number so in the name of the petitioner without proper opportunity of hearing.
So you want a partition should be carried out in your name without proper opportunity of hearing. Fantastic. And this case has been pending since. I think you must have been shy of taking the steps because the other people will laugh. Isn't it? Yes.
And the way it will be disposed of.
There is no stay.
First,
That is why.
the
And you were asked, in the interim, the petitioner should be served with a copy of the partition petition, and then her written statement should be taken into account before proceeding further with the application for here. You do it.
that is the last. Will be yes.
I'm dismissing your petition. Heard Mr. A. Rusid, the learned counsel appearing on behalf of the petitioner. Mr.
1, 2, and 3.
H. Sharma appears on behalf of the respondents numbers 1, 2, and 3. Petitioner has approached this court challenging the notice dated
Lecture 4.
challenging a notice enclosed as Annexure A to the writ petition, whereby the petitioner was asked to appear on 9/6/2016 at 11 a.m. in the office of the Additional Deputy Commissioner, Bongaigaon, for in connection with an application filed for partition of the land described in the said notice. Taking into account the provisions of section
This is not the only certificate notice, Lordship. Thereafter, another notice was also issued.
99 of the Assam Land and Revenue Regulation 1886, this court finds no infirmity in the said notice, dated notice enclosed as Annexure 4 to the writ petition. Accordingly, the instant writ petition is devoid of any merits for which the same stands dismissed. It is, however, made clear that the petitioner would always be at liberty, if the said petition proceedings have not yet been disposed of, to file their objections. In addition to that, the petitioner also has the liberty objection if the said partition proceedings have not yet been disposed.
Item 9. Order
Interim
implementing.
orders, if any, stands vacated.
Pass over for time.
Here's what is this? You want impleadment?
Impleadment, Lordship.
Who is you are? For the petitioner. You want to implead whom?
The present petitioner is the applicant also. He wants to be implemented.
Applicant where?
In the present case, one IA is filed by the applicant lordship, not by the petitioner, by the applicant who wanted to be implemented as respondent number 5 in the instant application.
Where is the petitioner's counsel?
PK Das, Mr. S. Sharma.
Hello, we do one thing. Where is the order? In the order. Madam, how are you involved? You are for the petitioner or the applicant?
Applicant lordship. And according to her application, she is the absolute owner of a land, 2 kathas comprising of Dabnanga 327 old, 874 new of KP Patta number 14.
Yes, you are for the applicant.
Your Lordship, here two confusion is there, Your Lordship. The petitioner, in Your Lordship, 8328, Your Lordship, made three clear, Your Lordship, made three clear, Your Lordship. That for the, to restrain the respondents from constructing or development over the scheduled land, Your Lordship. But that scheduled land, 3.7 acre land of mine, Your Lordship.
3.74.
That is, my absolute ownership is there, Your Lordship. When I get to know that my land was partitioned, my land was some brick wall has been constructed over my land, Your Lordship, I immediately reported the mayor before Deputy Commissioner, Your Lordship.
So it is on the basis of which the impugn order was passed. It is on your application the impugn order was passed, but they have not implemented you.
Your Lordship.
This is an application filed by the applicant seeking impleadment as the respondent number 5 to the accompanying writ petition being WPC number 8328/2022. From the materials on record, it is seen that the petitioner in the accompanying writ petition have assailed an order dated 7/10/2022 passed by the respondent number 4, whereby the partition proceedings was dismissed and there was also a direction to maintain status quo order restraining the respondent, the petitioner, to construct or develop the said land. It is the case of the applicant that it is the land belonging to the applicant wherein the petitioner was raising construction and the petitioner's applicant have filed the complaint which was the and filed the complaint, and resultantly, the impugned order dated 7/10/2022 was passed. Pusto. Taking into account the above, this court is of the opinion that the applicant herein is a necessary party to the accompanying petition. Accordingly, the applicant herein is included as the respondent number 5 to the accompanying petition. The counsel for the petitioner is directed within 7 days from today to file a fresh memo of parties before the registry of the court, and on the basis thereof, the registry shall make necessary correction in the post title of the petition, as well as also update the same in the CIS. Full stop. It is further observed and approved by. Full stop. I stands disposed. Not like you, main complaint. Is so and so appearing on behalf of the newly impleaded respondent number 5 submits that she requires 4 weeks time for filing the affidavit in opposition. The H. Sharma, the learned counsel for the respondent
PN.
authority submits that he is yet to receive
No,
instructions.
we have filed our affidavit.
No affidavit is yet.
Right,
affidavit.
respondent number 4.
No affidavit is yet. Submits that as per his instructions, certain affidavit has been filed by the respondent number 4. However, the same is not on record. Lists the matter on 25th of September 2024. In the meantime, the respondent number of newly impleaded respondent number 5 is given the liberty to file their reply affidavit in opposition. Gustav. H. Sharma shall it is further observed and directed that the respondent, official respondent, shall is given the liberty to file their affidavit in opposition. That this court, however, also grants liberty to the official respondents to file their affidavit on or before the next date, if such affidavit has not yet been filed.
For admission, item 10, part third.
Yes, money paid. What? What is wrong?
Also, this is my instruction level.
The B.J. Talukdar, the learned counsel appearing on behalf of the Home Department of the Government of Assam, submits that the financial sanction of the amount of rupees 26 lakhs 88,935 have already been made by the Home Department, and the same have been placed before the finance budget department, and the amount would be released soon. The instructions so placed is kept on record and marked with the letter A. List the matter again on 6th of September 2024 on an update as to whether the amount have been duly released.
11,
Sometime,
What?
Lordship, we take it up after some time.
Why? Being. Time being. Is this? Giving effect to the impugned eviction notice. Direct the respondent not to take any steps regarding eviction of the petitioner from the land measuring 1 biga 4 kathas under dark number remand. Why?
Here, the land that is in possession of under dark number 630. The eviction notice that we have received is under dark number 602. And we have not received any show cause notice.
Number 82.
Yes. What is annexure 4?
Annexure 4 to the writ petition of the photographs. Your Lordship.
Huh?
Annexure 4 to the writ petition of the photograph of the land in question.
You have a gate. It's a road.
Lordship, it's a plot of land that we had. The boundaries are marked, Lordship.
Is your senior coming? Where is the notice?
Eviction notice is annexure number, annexure number 2, page 17.
Then
That come to.
your case is that it is a roadside reserve land.
Roadside. Only a portion of it, they have other lands, around 2,000 some bighas. But this particular plot of land is 1 bigha 4 katha. They have anchor supplements. 18 to
70s. You have land, lot of lands. They're not to be settled with such big companies. How are you going to be affected? Tell me. Get hold of your senior. I don't dismiss with the junior counsel out there. Okay. Get hold of your senior by at 2 o'clock. Your senior doesn't come, then the fate is on you. Dismiss to dismiss it. There's no second option. But the question is whether you want the dismissal in your hands or in your senior hands.
Man,
None appears on behalf of the petitioner on call. It is further seen that on the earlier occasion also none has appeared.
I see no legs, code number 15. This time is 30, please time up. Time.
What is your case?
I'm appearing from respondent number 4 here, right? The matter is dispute between the petitioner and the respondent number 4. We are the final sir. We sanction one rule in favor of the petitioner.
Yes, Mr. Mahmood. What is your case?
Well, my case was that I took the vehicle on hire purchase. I also paid money with the company disturbed and wanted to take the vehicle. Then there was a criminal case they filed against us. In that, the case has been dismissed. But as there was a threat, so we filed this case.
Nothing
So I think
remains.
at present,
At present, the vehicle must have gone 6 years. What happens? You don't have anything to do.
yes. It has become a
Infructuous.
because the issue has been resolved. Otherwise,
Resolved. It has been submitted at the bar that the issue in the instant with petition has been resolved amicably.
What am I giving you? Because like NI case that
dismissed. They filed
NI
case that
case
was
filed with the
dismissed.
petitioner has already been dismissed or default
By you.
by us.
But the apprehension still remains.
Apprehension is remain here. There is balance amount to be payable by the petitioner to the respondent number 4, Your Honor. He is yet defaulter, Your Honor. Is not paying any amount after filing of this writ petition, Your Honor.
Actually, my lord, my learned friend is submitting against.
No, Mr. Mahmood, it is a dispute between you and him. What does this writ court have to do? If they want to, why should, there is a hire purchase agreement,
Yes.
and why should this court under 226
No, this was
exercise?
In an urgent situation, they wanted to take up the vehicle.
Now what do you want?
Now
Withdraw or
case has
dismiss?
become
Huh?
Infectious, it has been infectious. It has become now infectious.
You say, he does not admit to be infractions. You say, you want to withdraw that it is infractions. Your submission. He does not say so. So the moment he says, it would amount to he giving up his right, which he is not.
No, he should say,
He,
because,
he would not say.
no, because he filed the case, this was dismissed.
That is a
maybe
different
4 years
thing.
back.
That is a different thing. That is a case under 138. 138 case may be dismissed for default. That is a different thing. But whether he has a right under the hire purchase agreement to take any action against you, that is another aspect.
Yeah.
But this is a dispute primarily between you and him. Why are you involving the state?
That shall remain open for them, of course.
So what to do? Dismiss?
Infectious otherwise.
No, he doesn't say it to be. You want to say infectious? I can.
But he said that is on record, madam.
Whether you want to say infractions, I can infractions and close it. But he does not. The dispute still remains as per him.
Then let it kindly come on next.
No.
Let me issue the instruction.
I am vacating the interim order. This can't remain. By this interim order, you have made this hire purchase agreement useless. This can't remain. This is an absolutely incourageous litigation. It's an absolute dispute between you and him. If you have any problem with it, go on. Do whatever you like as per law. Writ court is not there for helping all this. You don't pay, that is your lookout. Court cannot.
Infectious. That will, that will be.
Hmm?
The matter has become infectious, in that view, case may be closed.
The Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioners, that the petition has become infructuous. And as such, he submits that he would not like to press the instant petition. On the other hand, the learned counsel appearing on behalf of the respondent number 4 submits that the dispute between the petitioner and the respondent number 4 still continues as regards non-payment of the amount.
So they filed a clear case, that is dismissed, that
He further submits that only the case filed under section 138 of the Negotiables Instruments Act have been dismissed for non-prosecution. Taking into account the submission made by the learned counsel appearing on behalf of the petitioner, that the instant writ petition, that he would not like to press the instant writ petition, the instant writ petition stands dismissed on withdrawal.
being infectious.
Huh?
Being infectious.
Hey, no, dismissed on withdrawal. Interim orders, if any stuff.
All right.
14.
Yes. And the petitioner is not representing. He has a case also. None appears on behalf of the petitioner on call. It is seen that on an earlier occasion also, the petitioner had not appeared. It seems that the petitioner have lost interest in the instant proceedings. Accordingly, the writ petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated. Provident fund. Yes, what is this?
My lord, my lord, I'm appearing on behalf of the respondent number 2, 3, and 4, my lord. Pursuant to
Yes.
your lordship order, dated 12/2/2024, we have already filed our affidavit, my lord. Probably that is in the record, my lord.
You are for a petitioner?
No, I'm for the respondent, my lord.
For the respondent numbers 2, 3, and 4, Lordship.
Who is the Assam Tea?
We are, my lord.
Yeah, we are appearing, Lordship. Mr.
Yeah.
Exida, senior counsel. he
But
is
that is
appearing.
the writ petitioner is Assam Tea Provident Fund.
for the petitioner.
No,
Who is the petitioner?
there is the association has filed, my lord. In that,
Oh,
the retired
association
person
has
of the,
filed. Oh, that issue.
my
I
lord.
forgot whether they should get the medical reimbursement or not.
This is the third writ petition, my lord, in respect of the same subject matter, my lord.
Huh?
That is the third writ petition, my lord. The earlier writ petition, my lord, that I will draw your lordship attention to page 57, my lord.
Page?
Page 57, 57, my lord.
57. Yes.
That it just I'm starting, it is further provided that in the event such pending medical bills are prior to 22/7/2011, when the decision of the Board of Trustees was taken, such bill will be governed as per Rule 11 of the 1983 rules, and the subsequent bills would be governed by the provisions of the rules rates under the CGHS, my lord. This is the findings given by the coordinate bench, my lord. This has not been challenged,
This has attained finality.
my lord.
No, my lord. There the court had directed me to file a representation, my lord. They have filed another representation, my lord. That was also not considered, my lord.
Now, this is the representation would be only limited to the rate,
Right, my lord.
not anything which whether you will be entitled as per the 83 or not. That has already attained finality. Now the question is as to whether you would be entitled. You were asked to submit a representation.
My lord.
Now, thereupon you submitted a representation.
Yes, my lord.
Saying what?
Page number 58, my lord. That representation was also not considered, my lord.
Now, your representation again, you are saying as per Rule 11 of the 83 rules.
Yes, my lord. That was not decided, my lord. Yes,
No, no, no. This is the findings.
No, my lord.
No, kindly see page 57.
My death, the representation was disposed of only because of my, on the basis of resolution, my lord, the notification was issued, and that resolution was not challenged, my lord. That is why, my lord, that was closed, my lord.
Now, let us read this order. Being aggrieved, the petitioner have preferred the earlier petition directing the act to approach the respondent. Has been raised by as not are not made applicable to Now, kindly come to page 55, the last paragraph.
Last paragraph, my lord.
In such view of the matter, no infirmity can be found to the office order dated so and so providing for medical reimbursement to the members of the association as per the subsequent CGS's rules. Until and unless the petitioner association raises its grievance or makes a challenge to the decision of the Board of Trustees arrived in its meeting held on Iman, the subsequent conduct of the Secretary PFOA in applying the as per the new scheme cannot be faulted.
Yes, my lord.
Now, as regards the other grievance of the petitioner that only 4 members have been given, this court is of the view that when members of the are made at par with other employees of the Iman and the other employees of the state are covered by the notification issued from Remand in respect. They may be applicable in their case and their any caution and exception as to why the members of theirs should be limited. Inside, this petition is disposed of with the direction that in the event the members of the petitioner are still aggrieved by the entitlement of medical reimbursement as per the new scheme, the petitioner may file appropriate application against the decision of the Board of Trustees in its meeting held on demand. In the event any such application is filed, the authority shall give due consideration to the issue. As regards the number of referral hospitals being restricted to 4, it is directed that all the referrals that are made available to other employees of the state government shall also be made applicable in respect to the members of the petitioner association. For the purpose of making all the references being made available in demand, the petitioner application shall be issued by the state government. It is also submitted that as large numbers of pending bills in respect to the members of the petitioner, further provided that in the event such pending bills are prior to so and so, when the decision of the year was taken will be governed by rules so and so, and the subsequent bills will be governed by the provisions of so and so. It is also provided that if the people are further aggrieved regarding the rate of medical to be made applicable to them in respect of years subsequent to Remand on Iman. So you have been given the liberty to challenge this decision of 22/7/2011. Now, thereupon you challenged it.
Yes, my lord.
You have challenged it here.
Here, my lord. The decision is start page number 28, my lord. '29 is the notification, my lord, office memorandum, my lord.
So you have challenged this. What is your ground of challenge?
Because, my lord, we are governed by the 83 rules, my lord. And we are the pensioners, my lord. All these people, and after my retirement, my lord, we are getting the full reimbursement since 1983. Prior to that, also I will doing, my lord. But rules were framed in the year 1983, my lord. As per rules, my lord, we are eligible for full reimbursement, my lord.
Is the petitioner association
Pensioners, my lord. Only
are all
pensioners.
pensioners?
Only for pensioners, my lord.
So there are now they have been all the pensioners now are being given a different one. Earlier they were getting this,
We are getting this.
and now they are. Now,
And
what is your right to get this as per the earlier one and not the present one?
My lord, in present one, my lord, there are
I know what else is wrong. You say that it is partial. It is partial medical reimbursement compared to the earlier where it was full.
my lord, in the service premium, I have contributed from my salary, my lord, for PF fund, etc., my lord. I have contributed, my lord. And during the entire life, my lord, thereafter I have retired, my lord. After retirement, they have taken the service entire life, my lord.
When did you retire?
Some 10 years ago, some 20 years ago, my lord.
Now, if a person has retired after 2011,
That case would be the difference, my lord. We are all the, prior to 2011, my lord.
how do you say all are 2011? Because this is an association.
Association, my lord.
Does a person who retires subsequently doesn't become a part of the association?
My lord, kindly see, my lord, paragraph, page number 30, my lord, for the time being, my lord.
30? Yes.
Pursuant to the decision of the board trustees to apply the rate under the CGSC rate method for reimbursement of medical expenses for the board's employee, the medical bills of the board's employee and pensioner will be reimbursed as per declared CGSC with effect from 1/9/2011, my lord. But that was, my lord.
But in this notification, there are nowhere mentioned about the rules of 83, my lord, which is applicable earlier, my lord. That rules were not amended till date, my lord. There is a rules of 83, my lord.
Where?
I put out the rules in the paragraph, my lord. Rules 11, my lord. Cost of attendance and treatment, my lord.
So is it your case that when the rules are already there,
Here, my lord.
court cannot take a separate decision?
Yes, my lord. And that decision was taken without the approval of the government, my lord.
Is it required?
My lord.
No, these rules are made by whom? Under what provision these rules are made? Are these statutory rules? Yes, Mr. Das, is this a statutory rule?
My lord, this is actually this is on the person to the resolution passed by the Board of Trustees, my lord.
Huh?
By the Board of Trustees.
No, understood.
My lord.
But if these rules are not amended, can the Board of Trustees take another decision?
No.
Or can you say that the Board of Trustees decision can supersede the rules?
Not that is about that. My intent also in my.
That is the most pertinent. That is not the, that is the most pertinent question.
My lord.
As to whether the Board of Trustees can override these rules. If they can, very well. The rules on the face of it does not say that the decision of the Board of Trustees shall prevail over the rules. It does not.
In fact, this is by of an amendment of this rule 12, rule 11, my lord. This resolution was passed, my lord.
Huh?
By the resolution passed by the Board of Trustees, my lord. That is in partition modification of this rule 11, my lord.
Understood. But if the rule says a particular manner in which it is to be given,
My lord.
can the Board of Trustees do a thing which is contrary to the rules?
My lord. But basically, let the petitions be directed to submit a list of these members of their association, my lord, who have retired prior to that, my lord, at 22/7/2011, my lord. Let them submit their list of members, my lord.
So they will submit, but are you saying then or conceding that those who retired till 22/7/2011, they will be given that?
But that is also finding of the coordinate bench, my lord. That I have already applied.
No. They are saying, coordinate bench said that those bills which were pending prior to that has to be given as per the 83 rules. I'm not on that. Here is the question which are you submitting, that those persons concerned who have retired prior to 22/7/2011, are you going to give them the benefit of the 83 rules and not the decision?
Correct, my lord. But you can go against these findings given by this coordinate bench, my lord. That we are doing, my lord.
This court has not, the coordinate bench has not stated that. Coordinate bench has only stated that the bills prior to so and so would be given. Just for example, a person A, he may have retired prior to 22/7/2011. but his bill may be of the year 2024. Are you going to give him that?
No, that will not be, my lord. That will not be
So
considered.
therefore, that is not the question. Therefore, my question out here is as to whether can the Board of Trustees supersede the rules by an executive decision? That's all.
My lord, for that, can I pay for at least a week's time, my lord?
Entitled to receive full reimbursement from the board of the cost of remand. This is the rule.
Well,
If these rules come under what?
well,
Under
That is
what provision these rules are made?
that was the rules I was framed by the state government, my lord.
These are state government frame rules.
My lord.
And you have modified it, Board of Trustees.
By the state government, my lord. This rule has been approved by the state government.
But they,
Well,
the matter, state government,
Respondent number 1 is the state government, my lord.
so without the state government, is it the decision of the state? The state government has no business to do anything here. They may approve the rules, it's a different thing.
Well,
But the state government also cannot change the rules unless the rules are amended. So the question is, can you take away the rights as in terms with Rule
Rule 11, my lord.
11 without making an amendment to the rules? That's the only basis on which the writ petition hinges, nothing more than that, more or less.
Now,
I've
for
heard
that,
the
my
matter.
lord, my lord, for that, I may be given a 1 week's time, my lord.
What affidavit? No affidavit. Only one, this is a question of law as to whether you can amend the rules without amending the rules. Can the Board of Trustees take a decision?
Well, yes.
That's all.
Yeah.
Chalo. Mr. So and so, the learned counsel appearing on behalf of the petitioner. The NCDA, the learned senior counsel, appears on behalf of the respondent members. No, two,
2, 3,
2, 3,
2,
and
3,
4.
and 4, my lord.
And Mr. So and so BJ Kalte appears on behalf of the respondent number 1. The issue involved in the instant writ petition relates to a challenge to the decision taken by the Board of Trustees dated 27/7/2011, whereby a decision has been taken to grant
The reimbursement, my lord.
to the pensioners in terms with the CGHS scheme. Full stop. The counsel appearing on behalf of the petitioner submits that the petitioners have all along been enjoying the benefit of the Assam Tea Plantation Provident Fund and Pension Fund Employees Medical Benefit Rules 1983. Referring to clause 11 of the said rules of 1983, the learned counsel submitted that a patient would be entitled to receive full reimbursement from the board of the cost of medical attendance and treatment in a hospital as described in the rules. In addition to that, all professional fees paid by the patient to the specialist medical attendant on advices of the authorized medical attendant shall be reimbursed by the board. The learned counsel submits that the decision so taken, which is dated 27/7/2011, which is the subject matter of the instant writ petition, which have been challenged in the instant writ petition, the Board of Trustees have decided that the members of the petitioner association would only be entitled to the rate under the CGSS for reimbursement of medical expenses for the board employees and the cost of treatment beyond the CGSS rate for hospitalization oblique treatment shall have to be borne by the employees oblique pensioners oblique family pensioners. A question therefore arises in view of the respective submissions made by the learned counsels appearing on behalf of the parties as to whether the Board of Trustees could have taken a decision in the minutes in the meeting held on 27/7/2011, which was thereupon notified by the office memorandum dated 17/8/2011 without amending the Rule 11 of the Rules of 1983. Mr. N.C. Das, the learned senior counsel, appearing on behalf of the respondent number 2, 3, and 4, submits that he would take instructions in that regard and sought for a week's time. List the matter on 29th of August 2024 at the top of the list, on which date an attempt shall be made to dispose of the information.
Obliged to your lordship.
Yes, Mr. Ali.
Item number 48, your lordship.
What is that?
Better your lordship, where your lordship dictated the order also to some extent. Better your lordship, it has been marked extensively, and your lordship dictated the matter also, your lordship. Here I saw one point.
Oh, that one, where FAO,
Let, lordship.
as regards the undertaking not given
Yes,
by the
so
respondent.
undertaking, I have given to undertaking,
We'll see,
and dictated also to subs,
take it up at 3.
3, your lordship.
Sometime
No, no, no. Now it is absolutely in your hands, the matter requires to be dismissed.
continuing in court number.
So what? I can't help you now. Okay, let me just finish it with Mr. Mishra, your matter is there, na? Did you get the instruction as to whether the permission was taken from the Director of Municipal Administration? There also you are there. Another matter.
My lord, the two possibly a bit contradictory, but I'll clarify.
Yes.
My lord, if your lordship look at the WT message, my lord, this refers to, if your lordship look at all chairman, executive officers of municipal board. That was issued on, my lord, March 2020. Now, the board, my lord, superseded just after that. Now, therefore, this appears to be in respect of all the, my lord, executive officers. Now, my lord, my learned friend has given a letter. I don't know how that can be substantiated.
This order was passed without the approval.
They are saying there was no approval. But then WT message makes it very clear it is in respect of all chairmen, executive officers.
But then also, he only steps into, as an executive officer, only steps over and takes over the board. But then also the board's permission has to be, the director's permission is to be required as per the proviso to section 229B.
But mainly to take over charge,
He will take over. There is no quarrel. He will take over. But the power which is to be exercised by the board can only be exercised with the approval of the director of municipal administration.
Even at this stage also that can be given. Otherwise, how they will work? Because the approval is invariably will have to be.
No, as of now, all this while nothing has happened. So we have to set aside. Now, executive officer can still take over that area. We set aside this, take over the area, then pass the area with the due approval if he finds that. No quarrel with that.
That can be.
On the day, by the ship made a proposal or observation that the lordship will direct them to obtain approval at this impugn order. Meanwhile, the impugn order will be stayed. But because if
No, that I will take care of that. As the matter is pending, let it be decided and decided this way or that way.
Yes.
Because their application is an application on the 177.
Yes.
So if that application, they can do very well till the disposal of that application, this proceeding, the order of the chairman shall remain pending.
one more thing. So these people are not trying to gather any sympathy, but they are not only illiterate. They don't know anything. And they went to obtain instruction, they were chased away. Very poor people. So taking advantage of this order, he may try to take over the position. I'm just expressing, so your lordship will say that your lordship is not saying anything on the title or anything of anybody. So otherwise, they will, with that, they will say, one in the High Court.
Law is very clear, even as a lordship is aware, a person in unlawful position, they cannot be disturbed, save and except with the process of law.
And it is their case.
No, we are not concerned with the question of possession or dispossession is another aspect of the matter. Anybody can file a suit or whatever may be, they let them do. That is, I'm not bothered with that.
Very good.
My only question out here in this matter is as to whether the order which was been put to challenge was with the due approval of the.
Right.
And there is no approval, so under such circumstances. However, taking into account that the proceedings are pending before the executive officer, who is taking over the realms of the board. So till that the effect is not to be given by the executive
Yes.
officer. And the decision be taken within a period of 4 months.
Very well.
This is a fair thing. What do you say? There you have no problem. You don't require a senior. Heard Miss G. Duggar,
Bhattacharya.
A. Bachcharya, the learned counsel appearing on behalf. A. Hendy appears on behalf of the respondent numbers 1 and 2. Mr. S. Dotto, the learned senior counsel, represents the Silchar, the executive officer. You appear for the executive officer.
Well.
The executive officer of the Silchar Municipal Board. And Mr. D.K. Mishra, the learned senior counsel, assisted by Mr. B. Prasad. Counsel appearing on behalf of the private respondents. This court heard the incident with petition at length on 13/8/2024 and passed the following order, which is reproduced hereunder. So order to reproduce quickly. From the above order reproduced, it would be seen that this court, taking into account the provision of Section 299B of the Assam Municipal Act 1956, sought for instructions as to whether the executive officer, while passing the impugned order dated 11/2/2020, had exercised the powers with the due approval of the Director of Municipal Administration, taking into account the proviso to Section 299B of the Act of 1956. Today, Mr. J. Hendy, the learned counsel appearing on behalf of the respondent number 2, placed before this court an instruction issued by the Director of Municipal Administration dated 16/8/2024. From the said instructions, it is apparent that from the said instruction, it is seen that the Directorate did not receive any proposal seeking approval from the Director Municipal Administration prior to passing of the order dated 11/12/2020. It is 11/2 or 11/12? ইয়াত কোৱাত ভুল হৈ আছে দেই, it is 11/12/2020. In addition to that, it is also mentioned that no approval was issued to the Silchar Municipal Board in respect to the impugned order dated 11/12/2020. The said instruction is kept on record and marked with the letter X. Taking into account in the instant case, as submitted by Mr. S. Datta, the private respondents have filed an application in terms with the second proviso to Section 177 of the Act of 1956. The second proviso stipulates that the board at any meeting may, instead of requiring alteration or demolition of any such building, except by way of composition, such sum as it may deem reasonable. Therefore, the power which was exercised by the executive officer in passing the impugned order dated 11/12/2020 has to be construed as a power exercised in terms with Section 299B that too of the board. However, as it is apparent from the communication kept on record with and marked with the letter X, that there was no permission taken, prior approval taken from the order dated 11/12/2020 ex officio is without authority of law and consequently requires to be interfered with. Accordingly, the impugned order dated 11/12/2020 is set aside and quashed. Next. This court further takes note of that in view of the setting aside of the order dated 11/12/2020, the consideration of the application by the executive officer, who is also presently discharging the functions of the board in view of the dissolution of the Silchar Municipal Board. Has to be taken up for consideration. Under such circumstances, this court directs the executive officer of the Silchar Municipal Board to decide the said application so filed by the private respondents within a period of 4 months from the date of the 4 months from the date of the instant order. It is further directed that as the matter is pending before the executive officer, as regards pending before the executive officer, the order dated 25/7/2020, 19. 25/7/2019 passed by the chairman of the Silchar Municipal Board shall not be given effect to. Next, it is with the above observations and directions, the incident with petition stands disposed of. Next, before parting with the record, this court, however, makes it clear that this court had only adjudicated on the legality and validity of the order dated 11/12/2020 and nothing more. Yes.
It was given 4 months' time for disposal of the application. Now they'll have to get in the meantime approval from the director. The executive officer will have to write for getting an approval. And if there is delay in getting approval, then they just.
So that will be done, my lord.
Direction to manage, they will ask for it and within a certain period, they should give the direction to dispose of.
I reported to within 4 months say লিখিছো নহয় তাৰপিছত এটা line লিখি the executive officer taking into account that there is a specific direction to complete the exercise of deciding the application and application filed by the private respondents within a period of 4 months from the date of the instant order, the respondent number 2 shall duly consider duly no granting. Why should the director may not grant?
Exercise their power.
Huh?
Exercise their power.
Shall duly see to it that the power shall duly take note of that to grant or not to grant the approval is duly taken note of within this said period.
My lord, there will be a problem. Problem will be.
Problem is there, division bench is there. No
kindly,
more.
kindly, just 1 minute.
No. You
My
better
lord,
for the,
he will grant or he will not grant, that's going to affect. If he doesn't grant, then I will have left with no remedy. If he doesn't want grant exercise of power, not deciding my application. But if if the director says they will not grant at all, that will prejudice me because I will lose the forum.
if he doesn't,
Whether order is
no.
given in my favor or
No. If he grants or doesn't grant, it is absolutely with it because it has to be with the prior approvals.
Correct. So
Now, if
prior,
it is there, prior approval is there, then
So you
don't you think that there is a discretion of the director?
the director will ask for prior approval and they'll consider it. Well, if your lordship says that, that will be better instead of giving them a handle key, you may reject also.
I
Let
never
them
say
consider.
that. To grant or not to grant shall be
Therefore,
done
I'm
within
saying
this period.
your lordship ask them to consider.
I would not ask them to consider. Why should I ask them when it is absolutely within the realm of the executive officer to ask? What, as of now, the executive officer has not asked. And without the executive officer till date not asking, why should this court direct that you consider?
No, that's because you lordship kindly consider the submissions which has been made by municipal board. They considered that taking of charge as an approval for doing everything. That may have been a genuine misunderstanding.
There cannot be a genuine, they know. The municipal board has been in the helm of the
What has been
executive
argued
officer
before your
since long.
lordship. Yeah, I agree with your lordship.
I forget.
So what I understand, my lord, if your lordship says that they will exercise their power in accordance with the law, that will be, I think,
It is further made clear that within this period of 4 months, as directed, the executive officer it is made clear that the executive officer can exercise the power under the second proviso to section 177 of the Act of 1956, subject to prior approval of the Director of Municipal Administration. Under such circumstances, the executive officer, if it considers to exercise the said power, has to initiate steps for seeking prior approval. If such steps are being taken, the Director of Municipal Administration, that is the respondent number 2, is directed to consider the same in accordance with law. For granting approval. Shall consider, shall be at liberty to take appropriate decision in accordance with. It is, however, observed that the authorities shall complete the exercise within a period of 4 months as directed herein above.
Item 55 fixed at 2 p.m.
Mr. Where is that government? Mr. Talukdar, this matter you said last time it was infructuous, remember? Matter came up on 14/8.
Yesterday's matter. my lord.
Yes, not
So
day
in
before.
view of our statement, stand what has been taken by the state, my lord, that we have withdrawn that notification, NIT,
You have withdrawn this NIT
and call for a.
29/6/2023. Mr. B.J. Talukdar, the learned counsel appearing on behalf of the state submits that the NIT published on 29/6/2023 bearing number AFM oblique 9598 oblique PMMSY dash tender oblique 2022-23 oblique 4444 shall have been withdrawn by the state authorities. Taking into account that the instant writ petition challenges the said tender which have been withdrawn, nothing remains to be decided in the instant proceedings. Accordingly, the instant writ petition being infructuous stands closed. Interim orders, if any.
Item 57, fixed at 2 p.m.
Heard Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner. Miss so appears on, who appears for the revenue? So appears on behalf of the revenue department. Mr. Talukdar, you are appearing? Or no? Mr. B.J. Talukdar appears on behalf of the respondent number 2 and 3. Full stop. And Mr. D. Gogoi appears on behalf of the respondent number 5. Forest Department. No, you are not roped in. You are respondent number 5. The petitioner in the instant proceedings have challenged the communication dated 2/3/2024 issued by the additional district magistrate Nalbari, whereby the said official had directed the circle officer, Nalbari Revenue Circle, to seal the premises of the petitioner, as well as to take necessary steps for lodging of an FIR of criminal nature of acts and to take necessary action for compliance of the provisions of the prohibitory order under section 144 CRPC promulgated by its office order dated 29/2/2024. In pursuant thereto, the petitioners the petitioner was informed by the circle officer that the premises of its Blick Clean establishment would be sealed for violation of the Assam Brick Clean Establishment and Regulation Rules 2013. Thereupon, the petitioner submitted representations to the respondent authorities, more particularly the respondent number 2, however, did not receive any favorable result, and consequently, the petitioner was constrained to approach this court by filing the instant writ petition. It is seen from the records that notice was issued on 31/5/2024, and the respondents were directed to apprise this court as to whether the Assam Brick Kiln Establishment Regulation Rules 2013 have been published and have been given due effect. It is further seen that on various occasions, this court had granted opportunities to the respondent authorities as to whether the Assam Brick Kiln Establishment Rules 2013 have been notified or not by way of an official gazette. Nothing had been placed before this court in spite of various opportunities. It is, however, relevant to take note of at this stage that on 14/8/2024, when the matter was listed, this court adjourned the matter to be taken up today in view of the Standing Council of the Pollution Department, Pollution Control Board, having not appeared on 14/8/2024. Today also, none has appeared on behalf of the Pollution Control Board of Assam. This court have duly heard the learned counsels appearing on behalf of both the parties, of the parties who have of the parties who have duly appeared. The entire edifice of the action, the entire basis of the actions which have been taken against the petitioner is based upon certain inquiry report regarding violation of the norms of the Assam Brick Kiln Establishment and Regulation Rules 2013. As the respondents have failed to show that the said Assam Brick Kiln Establishment and Regulation Rules 2013 had come into force, in spite of various opportunities, the impugned order dated 2/3/2024, which is based upon the Assam Brick Kiln Establishment and Regulation Rules 2013, cannot stand the scrutiny of law. Accordingly, the impugned order dated 2/3/2024 is therefore set aside and quashed. All consequential action taken on the basis of the said impugned order dated 2/3/2024 is also set aside and quashed. The respondent number 4 is further directed. 3 is further directed to remove the sealing of the premises of the petitioner, which was made on the basis of the impugned order dated 2/3/2024. The same has to be done forthwith and not later than 15 days from the date of service of the certified copy of the order. Next. Before parting with the record, this court, however, observes and directs that the order so passed herein shall not preclude the Pollution Control Board to take such action as envisaged under the extant laws.
Record as for Pollution Control Board.
Very.
Person typically he has to leave the court early today. He requested me to appear
Mr. S.R. Borua,
on behalf of S. Borua.
are you appearing?
On behalf of S. Borua.
Are you appearing for Pollution Control Board? Then I put it. If you are not appearing for Pollution Control Board, don't say that. Because we are in live streaming. It doesn't look nice to say that he is not here in the court, but to record the name.
Item 59.
And help it. Yes, what is this? Oh, this one. What case you have?
By filing this writ petition, my lord, of course, my lord, at the outside, my lord, I must say that, my lord. Lord, I am not a regular practitioner of tax, my lord. Even then, my lord, I got an opportunity. My lord.
Huh?
I got an opportunity, my lord, to argue before this court. And I may be given, my lord, some time to apprise your lordship. Filing this writ petition, my lord, we have challenged demand notice as well as subsequent order. Lordship raised a question, my lord, alternative remedy. Not mentioned. Lord, the ground on which the challenge was made, my lord, is common to many other writ petitions which are still pending before this honorable court with a stay order. Therefore, my lord, the question raised by this court whether writ petition is maintainable on the ground of alternative remedy, law is well set. In one of the cases, my lordship has, my lord, disposed of the matter, my lord, on the ground of alternative remedy. Then it was preferred before division bench with an appeal. Appellate court says the single bench did not commit any infirmity, nothing of this sort, because the writ petition could not have been made within the parameter of the law laid down by Supreme Court. Therefore, my lord, if my case is, my lord, under any of the parameters laid down by Supreme Court, then of course court has got jurisdiction to interfere and examine whether I am taxable, number one. Number two, whether, my lord, the interim order is with jurisdiction or whether it is barred by limitation. Here the question, my lord, now if lordship is otherwise satisfied that alternative remedy will not come into play, then of course lordship may interfere. My lord, today, other day, lordship was pleased to, my lord, pleased to, my lord, instruct the petitioner that whether the petition is maintainable, you were to, my lord, answer this question. So on merit, my lord, I am not going to make any submission.
What is the principle? Why the principles of natural justice have been said to be violated?
In the sense, my lord, of course, my lord, it is the admitted position that because of some reason, I was unable to, my lord, submit any supposed reply. Because
It's your lookout.
During that period, my lord,
Whether you have been issued the show cause notice.
my lord, a supposed notice was issued. And at that point of time, my lord, I say that, my lord, there was hardly any possibility on my part, my lord, to submit any supposed reply.
Why?
Because, my lord, at that time, my lord, I suffered from brain hemorrhage. And I was, my right side was completely paralyzed. I have, my lord, submitted a number of documents in support of my contention, medical documents. Thereafter, they issued the order. Now the question arises whether I will be altogether excluded from the opportunity of being heard. And in number of cases, my lord, at least one case I am having says that, my lord, even at the time of personal hearing, you are supposed to give me personal hearing. And at the time of personal hearing, I have a right to submit the written submission as well as the reply. That was not done. On the other hand, my lord, whether it is a case where the notice can be served beyond, my lord, 30 months, can they extend the period? Had it not been a case of, my lord, suppression of material facts or, my lord, contamination of the provision with intent to evade taxation, etc., or it is a willful misrepresentation or fraud, there are these, few circumstances under which, my lord, the period of limitation may be extended up to 5 years. Therefore, if it is, my lord, beyond jurisdiction, then it is a case of without jurisdiction. If it is without jurisdiction, then it will be one of the parameters laid down by Supreme Court to interpret.
Mr. Purkasto, if I may advise you, the best order you can get is that this is a natural gesture, whatever may be. The best is I should dismiss this on the ground of alternative remedy, and during this period be excluded and allowing you to file an appeal.
Then, Lordship,
That is the only thing you can best get, because the moment if I just dismiss it on the alternative remedy, which I am going to do, you have a big problem, because you see the notice was issued
yes,
when
yes. Don't you
you received the notice on 23/4/2021. All your troubles or any problems with your health happened only in the month of May 2022. You were given 30 days from April 2021.
My lord, whatever it may be, my lord, if your lordship is
You
otherwise-
were not initially the first counsel. That is the problem. It would have been otherwise taken care of properly. There was earlier counsel who did not prepare the brief properly.
Therefore, my lord, I appreciate your lordship's feelings, my lord. If any alternative, my lord, opportunity is given to me to approach the authority and file.
Approach, no, appeal.
Yes, yes, appeal.
Appeal. Nothing more than that. Appeal time is how much?
Now, time each,
What is the appellate provision? What is the limitation for that?
now lordship under G 107. Per section.
Huh?
Now under 107.
How much?
60 days.
Huh?
60 days. 60 days.
File your appeal within 30 days. They will decide on merits. You have no objection?
Yes.
That is the only
Yes,
way.
because my lord,
Mm.
admittedly, I could not prefer an appeal. Because
Because the division, no, why I'm saying is the division bench also won't grant you that also. They just dismiss, they will only dismiss it. Better take this 30 days from me.
Recently, lordship, full bench of Supreme Court has also.
Huh?
Recently, full bench of Supreme Court has also come to heavily on the High Court. Paragraph 15. Although this is with regard to DRT. Paragraph 15, lords.
What is this?
This is the full bench judgment of.
What is this full bench? 3 judges is full bench. Then what is Kesavananda Bharti then? Asking, let us also get more enlightened. Isn't it, Mr.? If 3 judges is full bench, and then what is Kesavananda Bharti? Constitution is as per 145 is 5 judges. What is full bench then? Full bench will be 13. What does it say?
Paragraph 15. It could be the same that the court has clearly held that the High Court will ordinarily not entertain a petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person. It has been held that this rule applies with greater rigorous in matters involving recovery of taxes, cess, fees, other type of public money, and use to the bank and other financial institution. Court clearly observed that while dealing with the petitions involving the challenges to the action taken for recovery, the public dues, etc., the High Court must keep in mind that the legislation enacted.
Well,
by
Mr. Kyle, all said and done, if you see, it is a self-imposed limitation.
That I'm not
self-imposed limitation. At one time, this alternative remedy used to be a constitutional provision, which was 226(3) then. It was brought in by the 42nd Amendment, wherein it says that if you have an alternative remedy, the High Court cannot. This was specifically removed by the 44th Amendment, and thereupon it is now being said to be a self-imposed. Therefore, if we see the all other laws which are there, if it is a case where a jurisdiction is not there, if it is a case where there is a violation of the principles of natural justice, then obviously, or if it is a case of something, a legislative enactment being challenged, why not?
Therefore, my lord, the question is, my lord, whether
However, Mr. Pukasta do not come within that. It's a different aspect of the matter.
question is, my lord, whether my case falls within the.
No,
my lord,
it doesn't. It doesn't. It does not. It doesn't. I'm just extending your limitation. Mr. A.K.
my lord, Lordship,
Pukasta.
may I just make a prayer?
Yeah.
Because period of limitation is 60 days. I will be in big troubles, my lord, by that time. So Lordship, may I condone the period limitation is 60 days.
That is why I'm saying that if you file your appeal within 30 days, the appellate tribunal shall consider your case on merits.
Yes.
That is what my order is. Heard Mr. A.K. Pukasta, the learned counsel, appearing on behalf of the petitioner. Mr. S.C. Kyle appears on behalf of the Ustuk. The instant repetition has been filed, primarily challenging the order dated 26/3/2024, passed by challenging the order in original number 215/AC/DIV- capital I /CGST 2023-24, dated 26/3/2024, whereby the Assistant Commissioner, CGST, Division 1, Guwahati, isn't that? He's the assessing officer. I think he's the assessing officer. Assessing. This is an order passed. He'll be the assessing officer.
Yes, Lord.
Who's the assessing officer?
Commissioner appeal is the appellate authority.
Assessing officer had passed the order, thereby confirming the demand of service tax amounting to rupees 16,04,738 on the services rendered during FY 2016-17 in terms with the proviso to subsection 1 of section 73 of the Finance Act 1994. In addition to that, the petitioner was also saddled with the liability of interest and penalty as mentioned in the impugned order. This court further takes note of that the said order is appealable in terms with section 107
Now 107.
is appealable to the
Appeals.
in terms with section 107 of the CGST Act 2017 to the Commissioner (Appeals, Customs comma, CGST and Central Excise, bracket NER, comma, GST Bhavan. That too within 60 days from the date of the said communication. Post. Next. The case of the petitioner is set out to challenge the said order, impugned order, before this court is that the petitioner could not, the petitioner, on account of difficulties, on account of personal difficulties beyond the control of the petitioner, on account personal difficulties arising out of health issues, which was beyond the control of the petitioner, the so-called reply could not be submitted. And as such, have invoked the extraordinary jurisdiction of this court under Article 226 of the Constitution. In spite of the statutory remedy available. At this stage, this court finds it very pertinent to take note of a recent judgment of the Supreme Court in the case of PHR Invent Educational Society versus UCO Bank and others, reported in
under DRT, I think.
two 2024 6 SCC 579. Wherein the Supreme Court dealt with the concept of dealt as regards exercise of jurisdiction under Article 226 of the Constitution vis-a-vis availability of alternative remedy. Though a perusal of the said judgment reveals that the said judgment was delivered in the case of a proceeding under the securitization and reconstruction of financial assets and enforcement of Security Interest Act 2002. But this court finds it relevant to take note of the observations of the Supreme Court at paragraph number 23 of the said judgment, which is reproduced hereunder. From the above quoted paragraph of the said judgment, it is seen that the Supreme Court made it clear that the High Court ought not to ordinarily entertain a writ petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person, and such a principle should be applied with great rigor in matters involving recovery of taxes, cess, fees, and other types of public money. This court also finds it relevant at this stage to take note of another judgment of the Supreme Court in the case of Godrej Sarali Limited versus Excise and Taxation Officer come Assessing Authority and others, reported in 2023, bracket of 109 GSTR 402, wherein the Supreme Court observed that a writ petition can be entertained in spite of availability of an alternative remedy when, number one, the writ petition seeks enforcement of any of the fundamental rights, Roman 2, where there is a violation of the principles of natural justice, number 3, where the order or the proceedings are wholly without jurisdiction, number 4, where the virus of an act is challenged. In addition to that, it was also observed that when an issue is raised purely on a question of law, the High Court can entertain a writ petition. In the backdrop of the above, let this court consider as to whether this court ought to consider the entertain the writ petition at all. In the instant case, it is seen that neither of the grounds set out in the judgment of the Supreme Court in the case of Godrej Sarali Limited, Supra, is present.
They made out.
That is my observation. That is you have not. Merely because of the fact that the petitioner could not submit the representation, reply to the show cause notice on the ground that he was incapacitated on account of his health problems. Cannot be a ground to assail the impugned order. More so when the documents enclosed to the writ petition do not show that the petitioner was incapacitated from filing the reply to the show cause notice. Therefore, the question of violation of the principles of natural justice as claimed by the petitioner do not arise. Under such circumstances, this court finds no ground to entertain the instant writ petition, taking into account that there is an alternative and an efficacious remedy available to the petitioner, for which the instant writ petition stands dismissed. Before parting with the report, this court, however, takes note of that the petitioner herein approached this court by filing the instant writ petition. And this court, by an order dated 28/6/2024, had issued notice. And there was also an interim protection granted not to take any coercive action on the basis of the impugned order dated 26/3/2024. Thereupon, the matter has been pending before this court. Under such circumstances, this court, in the interest of justice, under such circumstances, this court had put a specific query upon Mr. S.C. Kyle, the learned counsel appearing on behalf of the respondents. Under such circumstances, this court is of the opinion that the interest of justice would be met if a further 30 days of time is granted from today to the petitioners to file an appeal before the appellate authority, as mentioned in the order, the impugned order, as mentioned in the impugned order itself, impugned order dated 26/3 itself. Accordingly, this court directs that if the petitioner herein files an appeal within 30 days from the instant order, the commissioner appeals shall decide the appeal on merits without going into the question of limitation. With the above the petition, I open the thing for you for next time.
Instead of using the word made of dismissal, it may be disposed of.
Dismiss with cause to lekho. Yes, it has to be dismissed. your own submission of there that you have applied for a settlement of that.
It found to be, my lord. It found to be, my lord. My lord, here, you also see, my lord, you can also see the paragraph four of their affidavit, my lord. It is at the behest of some others, my lord. They wanted to open some market there.
No, that's a roadside land they are saying.
Not, my lord, if you also see, my lord.
Now,
the
you say
line-
that it is not a roadside land. It is not a roadside land. That is your statement. You say that the land, first land is 611,
One,
which is a road. Then comes another land, which is 612. This is a reserve forest. And then comes 613. Then comes 602. 602 is yours.
my lord.
Understood? 602 is yours. So 613 is not yours.
Not mine, but I have applied for survey. They say the survey is kept pending for rainy season.
Okay, now let them survey and if it is found that demarcate and then ask.
No, moreover, my lord, I'm relying on your lordship judgment as well as, my lord, division bench judgment as well as the other judgments of the division bench.
What does it say?
One is 2018 2 GLT, and other is, my lord, 2020 2 GLT.
What does it say?
My lord, in one case, it is said, my lord, that they should go for alternative remedy, my lord, civil suit, my lord. Actually, that is that. Second, in, my lord, it was demanded back to the deputy commissioner for press consideration. 2018, my lord, that is a case, my lord, where it was sent back to the holder. There also the case was that, my lord, they are imposing the land for the last 100 years. So bona fide claim of right is there. So to send back.
A bona fide claim of right. How can there be a bona fide claim of right upon you?
Then second one is, my lord, that is 2020 2 GLT, my lord. There, my lord, they said that liberty is given to authorities to proceed for eviction under the provisions of any other appropriate law.
1989 is a different judgment.
No, 89 is different, my lord. 89 is regarding boundary. No boundary has been given here. That is,
Then?
but 2020, my lord, 2 GLT.
So you say,
2022 GLT, my lord, that is same, my lord, that they should go for alternative, my lord.
no, here it says that the appellant was put into possession of the plots of land through certain instruments made either by the department or the GMC or other. That this was on the basis of which where the entry was properly done. But here there is no entry.
The other case, my lord, 100 years, my lord, position here, 65 years position, my lord, 60 years. And whether that they are also, well, that is doubtful, my lord, because no survey has been done because of the rainy season. They have said so.
No, therefore I'm saying let the survey be completed and done. And then if it is found that you are in encroachment of 613 to evict you.
Then, my lord, I may be, remedy, my lord, if anything is there.
What remedy? The notice which was issued thereafter, there has been lot of, you have yourself approached there and said that first you carry out the demarcation. Then you say that, okay, give me a settlement.
So, if it is, my lord, that is.
Now, unless you have a right of settlement, you have no right to remain in possession of government land.
That can, my lord, demarcate the first one.
No, demarcate and evict. Both has to go together, no? Demarcate and evict. And found that
the
if
demarcation
613, not to disturb your 602, but 613 has to be removed because it's a government land. Unless you show that you have a right,
My lord, this long possession.
a long possession does not give you a right. You have, you see, one has to also take note of these are government lands for the purpose. You are a big company. You have 2,400 bighas of land. No heavens will fall with 1 bigha of land.
But here your lordship.
For
see,
you, if it
how
is
will it be
given,
affected? They have not said anything in the notice. Now in the affidavit it comes to notice that these persons approach them saying that it's a roadside reserve land. So they should be evicted and bazaar should be.
no bazaar business.
Yes,
that para 4 of the affidavit? Para 4 are there, second para.
Relating to the encroachment of roadside reserved land by so and for demarcation of so, Mani Krishak Bazar complex. After the inquiry report submitted by the so man, subsequently the ADC so instructed to evict an encroachment and demarcate the boundary of so immediately. Thereafter, as per the order, the official proceedings were initiated and the said notice was issued.
So here, directed the circle officer to Galar to conduct an inquiry on the petition submitted by, say, Dinesh Gogoi and 108 others relating to encroachment of road reserve land, tag number so, Mahakali said, and for demarcation of Potumoli Krishak Bazar complex. So this is the
Your statement later on, you were saying that necessary steps along with forwarding for authorized here with a prayer to settle the excess government land under so under Moa Moza so if any have been absolved within dark number so. And they categorically say respect in here is a roadside reserved land which was reportedly encroached.
That is from the
Roadside
map,
land, no business.
map, from a map it shows Malad is not correct.
Huh?
From the map it shows that no, it's not correct.
No, I've seen the map.
Yes. You're
The map is enclosed at page 37.
611 is the road.
Yes, I've seen it.
Then
611 is the
612
road,
is the middle.
612, 613. This is the land.
How 613 can be roadside Malad that land? Malad?
613.
Cannot be Malad. That's a wrong Malad.
They want to enlarge the road. Make it big. But that
because-
also, no. What is the breadth? Tell me.
Hello?
What is the breadth of the road?
Anything Malad.
No. Your road. What is the breadth of your road? It is also a road.
No.
What is the breadth of that 1 bigger land?
Cannot stay Malad.
You have to say.
No, Malad, because no notice, nothing has been given to me.
No, I'm asking you. You are in possession of that.
Malad,
What
I can't
you
say
have
Malad.
given a photograph at page 21. This is the road.
I am saying that what I purchased from the original owner, that I am possessing.
Whatever may be, that doesn't mean that you have not purchased this plot of land.
That after demarcation only that can be seen.
You are not denying to that. Therefore, I'm saying if it is demarcated and found that 613 is the land you are in occupation, then they will evict you. That's all. You have no right. Because as of now, as per the land policy, do you have the right for settlement? Tell me. If you have, I will
Hello, right.
help you.
I only
The
one of
basis on which it has to be given merely because you see, one has taken note of these are government lands. We may ask them to also again initiate action again under the Assam Fixation of Land Ceiling Act. Mr. Talukdar, what do you say? Initiate again another year of under Assam Fixation of Land Ceiling Act and that some more land if it is there. They are holding a huge land of 2,400 acres.
2040 bighas. Then
Yes.
that effort they are encroaching.
And then that is enough. But I think you demarcate and then only you evict. If it is found that it is outside, means if they are in possession, first demarcate which way and thereafter you evict. Heard Mr. G.N. Sahewala, the learned counsel appearing on behalf, senior counsel assisted by A. Bhattacharjee appearing on behalf of the petitioner. The DJ Talukdar appears on behalf of the respondent number 2, 3, and 4. And 1 also. Why home?
home. I don't know.
Why have you made home? He appears for 1, 2, 3, 4. The petitioner herein have a sale, a notice dated, what is the date?
20, my lord, it is
16/7/2018, whereby the petitioner was informed that it was illegally possessing a plot of land measuring 1 biga 4 katha 17 lechas under village Podumini, Moza Mohua by erecting a fencing. Pustu. From a perusal of the materials on record, it is seen that the petitioner company purchased a tea garden which consists of total 725 bighas, 1 katha, 13 lechas of tea garden as on 8/5/1958. Pustu. The dispute arises as to whether the land presently under the occupation of the petitioner, which have been alleged by the respondents to be dag number 613, is a part of actually dag number 602. Inasmuch as it was the stand as could be seen originally in the writ petition, that the petitioner claims that the land in their possession, which have been mentioned in the impugned notice as dag number 613, is a part of dag number 602. Pustu. It is also seen that the petitioners have sought for demarcation pursuant to the issuance of the said notice, impugned notice. However, from the affidavit in opposition filed by the respondent number 2, it is seen that though the demarcation was sought for, the same could not be carried out on account of the rainy season. It is also seen from the affidavit filed by the respondent number 2 that the petitioner have also submitted a letter to the ADC Revenue Golaghat with a prayer to settle the excess government land under dag number 613 of village Podumini, if any have been absorbed within dag number 602 and 603. This submission of the said letter for settlement was after the notice of eviction dated 16/7/2018. This court have also taken note of the affidavit in reply filed by the petitioner, wherein it denies the petitioners categorically denied that the land in dag number 613 is a roadside reserved land on the ground that the road in question is in dag number 611 and adjacent to that is dag number 612, which is a reserve forest, and thereafter there is dag number 613, which abuts the land of the petitioner in dag number 602. To that aspect, the petitioner have also enclosed a map, the survey map, survey map as annexure A to the affidavit in reply. In the backdrop of the above factual aspects, This court have heard the learned senior counsel, Mr. G.N. Sahewala, as well as Mr. B.J. Talukdar, the learned counsel appearing on behalf of the respondents. The learned senior counsel submitted that the land in question in dark number 613 cannot be a roadside reserved land. He further submitted that the petitioner company, after purchase of the said land from its predecessor in interest, have been enjoying the possession. And it is at the behest of certain persons the respondent authorities have taken action. To the said submission, this court had put the specific query upon the learned counsel appearing on behalf of the respondents, petitioner. As per the land policy of 2019, does the petitioner company have a right for settlement of the government land? The learned senior counsel submits that the petitioners have duly applied for the said settlement, but the said proposal for settlement have not yet been decided, as would be seen from the affidavit in opposition filed by the respondents itself. Upon hearing the learned counsels appearing on behalf of the petitioner, this court at this stage finds it relevant. Take note of the judgment of this court in the case of the division bench of this court in the case of Salakuddin versus State of Assam, reported in 2024 SCC Online SC GAU 629, isn't it?
Maybe I have a copy of the.
629. Wherein this court categorically observed that roadside reservation lands reserved for roadside reserved lands cannot be granted settlement in view of the mandate of Rule 23 of the settlement rules. However, as regards the other lands, settlement is, as regards wastelands, settlement is permissible, provided it meets the parameters in terms with the Assam land policy of Assam 2019. Under such circumstances, this court directs the respondent number 2, 3, and 4 to carry out the demarcation of dark number 613, which is the land on which the impugned notice have been issued. And if it is from the records seen that the said land is a roadside reserved land, the petitioner be evicted. However, if it is found from the records that the land in question is not a roadside reserved land, the petitioner is given the liberty to file a fresh application for settlement in terms with the Basundhara 3 portal, 2 portals, or in the offline mode by submitting form 125 and 126. Depending on the decision so taken in the said application, the respondent authorities shall take due steps as regards the land in question. With the above the instant petitions, let him file in terms with the, if first you find out, if it is a roadside reserve land, throw them out. But if it is not, then they file full stop. This court, however, further observes and directs that the petitioner shall file is given 10 days time from today for submitting its application for settlement in the manner stated herein above. Interim orders, if any, stands with.
Item 48 upgraded.
Where? Where is that latest one?
Lots of, although appellant side file fresh undertaking, but
Huh?
there is, although
Where
appellant
is
side
that? The last
file-
one?
fresh undertaking, but there is no board resolution.
Oh, again another problem. Mr. I told you last time, na, Mr. Ali. What's proper on the part to say furthermore.
Lordship,
Wait.
proper, say your lordship, the
Where is the affidavit?
director's signatory details.
Start from page number 277, Lordship.
And your lordship in the written statement, your lordship, I have specifically stated. The directors, your lordship, necessary here. So I will do on my behalf as well as on behalf of the
Mr. S. Ali submits that the undertaking so submitted on 9/8/2024 by both the appellants is supported by a resolution taken by the board of directors of the respondent number, appellant number 2 company. This the matter again on 30/8/2024. In the meantime, additional affidavit be filed bringing on record the said board's resolution.
bring it on record.
Board's resolution. You see, a director cannot say anything.
That's the written statement, I have already stated, your lordship. I am one of the.
Mr. Ali, you also know injunction written statement is not a proof. First you file that, I will do it. I'm ready to vacate it, only subject to the board's resolution. Bring it on.
Item 16.
Board resolution, your lordship,
I said that Mr. S. Ali submits that the undertaking submitted on 9/8/2024 is based upon a board resolution of the appellant number 2. And accordingly, list the matter on so and so, giving opportunity to you to file an additional affidavit to bring on record the board's resolution. Yes, none appears for the petitioner. Well, what is this?
After my lord, we are aggrieved by the order passed at page 80, my lord,
Not impugn order.
whereby they have sought to impose district mineral fund, my lord. The mining permit which was issued to us, my lord, for a period of 2 years. Thereafter, they imposed this, they issued this letter on 24/10/2017, my lord. Against this order, we have filed this petition in the.
I understood. What is the, where is the order?
This is the letter passed, my lord, page 80. This is the impute.
Page?
80.
Then you have challenged this.
Yes, my lord.
Why?
Because our period was for a period of 2 years. If my lord may kindly peruse page 11 of my petition, my lord.
Page
11.
11.
They have,
Page 11 is what?
this is my petition, my lord. In the petition, I have quoted the relevant sections, my lord.
Yes.
This DMF comes under section 9B of the NMDR Act, my lord. Mines and Minerals Development Regulation Act 1957.
Yes.
We were issued a mining permit which comes under Rule 21Y of the Assam Miner Mineral Concession Rules.
Ah.
That is a mining permit for a period of 2 years for a area which is less than 5 hectares. We were given an area of 2.90 hectares. Then my lord may kindly peruse.
Is it exempted? Is it exempted under the rule 9.5,
Yes, my lord.
9B5?
Because they are saying mining lease, we are a mining permit, my lord. Because the rule, the section 9B talks about mining lease. We are a mining permit and mining lease under the rule 8, if my lord may kindly peruse rule 8, next page, page 12, my lord. Mining lease is for a period of 10 to 20 years. Rule 8, grant of mining lease to competitive bidding. At page 12 down below, my lord. So this is.
No, that's the minor minerals rules conceive of a mining permit.
Mining permit, there are 3: mining permit, mining lease, mining contract. So mining lease is for a period of 10 years. If my lord may kindly peruse rule 8. This talks about no mining lease shall be granted by a competent authority unless it is satisfied that there is evidence to show the area for which the grant of mining lease is considered has been prospected earlier or so and so. Then sub-rule 2, for not less than 10 years but not exceeding 20 years. So mining lease is for a period of 10 to 20 years. Then my lord, next page, rule 23. This we are covered under mining permit, my lord. Subject to rule 5, mining or quarrying may be granted by competent authority in respect of any area not covered under any mineral concession granted under this rule in the following cases. Mining in respect of areas ordinarily less than 5 hectares. Our area was 2.90 hectares. So this is about mining permit, not about mining lease.
So you mean to say that you were given a mining permit and as such rule 9B shall not apply?
Yes, sir. And moreover, my lord,
Section 9.
if my lord may kindly peruse the rules, my lord, the act, my lord, MMDR Act, my lord.
Where?
I also quoted that, my lord.
Well, I'll try, subject to lordship's convenience, my lord. I like to cut short, my lord. My lords, what had happened, had I been that place, my lord, the argument is, my lord, these rules, my lord. Rule 14 of that MMDR, my lord. MMDR divides the minerals into two parts, major and mineral. The rule he's speaking about talks of major mineral. And we are the competent authority under section 4, section 14, my lord. He speaks of 9. 9 is not applicable to minor mineral. Section 14 of the MMDR, my lord. We need not go to those issues, my lord. Section 14, my lord. 5 to 13 is not applicable to minor minerals.
Section 5 to 13 not
Yes.
to apply to
So
minor.
that
minerals.
goes.
Yes. Then
And then, my lords, issue is, my lord, they.
and
yes.
minor mineral rules is under 15.
Yes, my lords. It's under 15.
15.
Yes, the issue, the mineral we're dealing is minor mineral. And the section he is quoting is of major minerals. So that can be cut short, my lords. And that apart, my lords, though I don't have the petition, my lords, I just went to the second copy. What I found, my lords, the settlement was of, there is a provision of mining permit under permit, my lords, for 2 years. For the area under less than 5 hectares. He's my lord, this he entered into a contract. It expired for after 2 years. That is 10 to 11. There's no point of giving a demand in 2018. And my lord, if we go to the contract also, it speaks of a fund. That fund is defined in the Assam minor mineral rules as fund minor mineral rules fund, MMDR fund, my lord.
So you mean to say his contract was from 2010 to 2012.
Yes, my lord.
And in 2018, this notice was issued.
Yes, my lord. That is a simple case, my lord.
Then what do you say?
Then, my lords,
That in
very frankly, my lord, the fund which they are insisting, my lord, perhaps I don't know who did this.
Where is the notice? Where is the impugned notice?
Page 80, my lord. Page 80. My lords. Well, his contract with us has been brought to a logical end. It has expired. There's no point of giving this notice.
No. But then also, why they have issued the notice to him?
My lords, perhaps they have misinterpreted the issue. What has happened, my lords? My lord, kindly does my lord. MMC rules kon ase ni?
Huh?
Some minor rules.
Yes, why you people have not written a book? Nowadays, everybody writes books. Write a book on minor minerals. Tell me.
So, my lord, there is a definition. My lord, he is giving a book. Yes. Yes, my lord, there is it starts from page 245 of that book. Minor mineral concession rules. There is a definition clause. Definition at 2. Definition, my lord, will kindly come to JKL. What is fund?
Mining permit has been a means of mineral concession other than a lease granted for a specific quantity of mineral to be extracted, collected within a specified period not exceeding a year. Now, these rules have come in 2013.
Yes, my lord.
And their periods end on 2012.
That's the issue, my lord.
What is this?
Period from 17 to 19, my lord.
Oh,
17 to 19.
It over like 2 years, 2 years. More petition.
period is from
I was
17
asking
to
him, I don't have the
19.
petition. I was asking him when was the
He should
settlement.
bring his own petition.
I don't have the petition. I was trying to help you. But that apart also, my lords.
Page
my lord,
31, my lord.
my lord, come to
17 to 19, my lord.
I'm trying to
Page
help him out,
30?
my lords.
31
Yes.
of the final letter of intent. No, letter of intent is given, then thereafter what happens?
The final letter of intent, my lord, is at page 106.
Basically,
Are also requested to And where's the contract?
Contract, my lord, is at page 88.
Page
88.
88. To come to the contract after the impugn order. That's it. So then, does it say about any funds?
My lord, it says about fund. That was, I was trying to help him out, my lord. It says about a fund, and fund definition we get from the definition of J, 2J. It speaks only of a fund called Minor Mineral Development Fund.
2Z.
My lord, in the
Who?
Lordship page 94, my lord, will find a mention of a fund of the petition.
Amount to be deposited on account of fund where the permit holder is operating, he shall pay an additional amount of 10% of the due permit along with the amount of so and so amount. Yes, this is the clause.
My lord,
So this page impugn order has to be restricted to clause 4.
clause 4, and also, my lord, the definition of fund.
Where?
I some minor mineral rules, my lord. Section 2.
Means the
Definition
mine
section.
and mineral development restoration fund created an establishment under these rules.
That's all, my lords. This order will go, my lords. That I was trying to help you, help him out.
Why will the order go?
Well, the order will be set aside, my lords.
Why?
Because, my lord, there is no, try to find, my lords, there is no mention of any district fund. Only fund is defined as minor mineral fund, my lords.
No. You see, at page this one, only see payment of bid security, so and so, so and so. Only come to page here. 10% of the royalty paid in terms with the second schedule to the mines and so in respect of the mining lease or as the case may be, prospecting license under so and so, 30% so and so. No, but then also he will be liable as per 4.
That he is okay. That he is not disputing that. He is asking, he is saying that we are demanding a fund called District Mineral Fund.
Where? What fund?
District Mineral Fund, my lords.
Where is that?
With reference to page 80, my lords, with reference to the subject cited above so and so, my lord, to discuss about government direction to district account of District Mineral Foundation Fund, my lord, DMFT fund,
District Mineral Foundation Trust.
my lord. Yes.
You can't take that.
I'm admitting that only, my lord. There's no clause out there.
You
in the
can
contract.
only take what is there in the
MMDR. That was I was pointing on.
Equivalent.
That's all.
And in the, even in the schedule of 9B, which we have challenged, that there is, you can't take it from 10% addition of the royalty. Because the District Mineral Foundation, if you see, stone is not there in the schedule. It is only sand. We have.
No.
given source.
9B does not apply.
Yes.
I'm saying,
9B does not apply.
yes.
So we are not concerned with 9B. What Mr. Gogoi say? Now, if you kindly come to page 94.
Page 94. 94.
So, in addition to the royalty,
Yes.
where the permit holder is operating the area, he shall pay an additional amount of 10% of the due permit money, along with the amount of on account of dead rent or royalty towards the fund.
As per the agreement, we have to pay.
So this you have to pay. But Mr. Gogoi also say that this what we have, this notice which was issued could not have been issued to you, taking into account that this is outside the scope of this agreement.
Yeah, that's right. That's our whole case.
He
If it
also
is
says.
outside-
But no, your case made out is on a different line. You said that 9B.
No, because-
9B and it is not, it is a mining permit, not a mining lease.
Yeah, 9B we challenge because they cannot ask for under the Mines and Mineral Development Law. This, under the Mines and Mineral Development Regulation Act, 9B they cannot, maybe they can, but that's our case. That is why we challenge it. Now the period is over, 2017 and 19, the period is there. Even then in 2018, we have.
No, but then also you were enjoying a stay order, na?
Yes, sir.
So
That will be
therefore, we have to
subject-
set aside
no, no.
this.
subject to the outcome of the writ petition.
No stay.
The money is with them only 10%, no stay. No stay.
Then they have
Subject to
you have paid the
outcome.
money.
Subject already they have, paid, yes,
Eh?
already deposited. Already it is with them. Security deposit is with them. So by way of security deposit, they will deduct the 10%. Security deposit.
Now
is
what
with
do you
them.
want?
People that should go. This impugn order should go.
Then thereafter,
Thereafter, my lord, this impugn order, they should refund. And 10%, if they are entitled under the.
directing the respondents to refund, adjust the amount of year deposited by the bidder after the expiry of a year. So did you pay that amount?
Yes, yes, it is paid. It is with them only, my lord.
Mr. Gogoi,
My lord.
you get your instructions
I'll
from
get
this. Have you taken the money?
My lord.
And thereafter we dispose it of.
My lord.
Disposed of. The heard Mr. D. Das, the learned senior
It is
counsel,
considered-
assisted by Mr. S.P. Count. He go for the petitioner, Mr. D. Gogoi appears on behalf of the Mine and Mineral Department.
No, no,
What?
it's Forest Department.
Forest here. The Forest Department of the Government of Assam. First, the petitioner in the instant proceedings have assailed the demand made by the Divisional Forest Officer, Dibrugarh Division, by the communication dated 24/10/2017 of a payment of rupees of 30%. You will come under 30% because 17 to 19.
10%.
No 10%.
Yes, yes, it is before. Kindly see.
No, your period is after 17/18, 17/19.
Come mining list or no after 12 January 2005.
15. No, honor after 2015.
Yes. Of the case in respect of minor or the case.
Honor after remand.
Honor after 12.
And yeah, 30% before year.
Yes,
Uh,
30%.
Funding an amount of rupees, the amount of 10% of the royalty on account of deposit to be made to the District Mineral Foundation Trust. The learned counsel appearing on behalf, senior counsel appearing on behalf of the petitioner submitted that the said direction by the impugned communication is unauthorized and unconstitutional inasmuch as the petitioner herein would be liable only to the extent stated in the agreement entered into on 28/12/2017 and closed as Annexure 12 to the petition. He drew this court's attention to clause 4 of the permit, which is at part 3 of the agreement, and stated that the petitioner's liability is only to an additional amount of 10% of the due permit money along with amount of installments on account of dead rent or royalty towards the fund. The learned counsel further drew the attention of this court to rule 2L of the Assam Minor Minerals Concession Rules 2013, wherein it has been mentioned that the fund means the Mine and Minerals Development, Restoration and Rehabilitation Fund created and established under the rules. The learned senior counsels therefore submitted that the said that the impugned notice therefore is absolutely without jurisdiction or without authority and without authority and the impugned notice is therefore without the is contrary to the law and for which the same requires to be set aside. It was further submitted that the amount of this 10% of the petitioner have already been withheld by the respondent authorities from its security deposit. And as such, there would be a requirement of passing consequential directions after setting aside the communication dated 24/10/2017. Then for refund of the said amount. Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that he would take instruction as to any amount have been deducted on the basis of the impugned notice dated 24/10/2017. It's the matter on when 31/8.
Father hearing. Father hearing.
51. Don't worry, I'm there for this month.
31 to Sunday, no?
31 year on which date such instruction. These matters have been only fixed for this portion, and then he will say no. I would have finished up if that aspect is not there, because I can't pass a direction. Because when he moved the petition, there was nothing. He said that this should be only taken after the mining.
But even then, if we apply 9B also, it is only in respect of these they can do it, not against.
No, Mr. Das, there is no quarrel that the imposition is bad. But the question is whether can I pass a direction for refund? They will only arise if they have taken. That is the only thing.
If they have taken.
Then only I can pass that consequence. Otherwise, to setting aside, there is no problem only. I could have done it now. This order was enough.
17.
Yes, what is this?
Yes, sir, I am applying for respondent of 4 to 7, Your Lordship. I did like to file my rejoinder, Your Lordship. We have served our Okalazum on April, October, Your Lordship. It was met during the pandemic period, Your Lordship. 144 proceedings filed during pandemic.
On car. Is this? And already did.
Fair room.
Yes, what is this? They filed the review, or he reviewed the order. Then why should we exercise 226?
What happened, Lordship? The action of reviewing the order, of initiating the process for reviewing is absolutely without jurisdiction.
Absolutely. There's no quarrel with that. But why should we exercise 226?
Because what happened, if your Lordship page 19, Lordship, petition code.
Yes.
This is the order passed by the earlier incumbent, Lordship.
Possession is declared to the first party so and so on the disputed land. Then what happened?
The case dropped.
Huh?
Last line, here the case is dropped.
The case is dropped. Giving the possession. Then
Lordship, I am in possession of the land. After that, what happened, Lordship? By the action 4, Lordship, the next page, he stated that the new incumbent stated that
as per the direction of the Deputy Commissioner, District Commissioner, and that's number 2, he has been instructed to review the earlier order. So we have
Wait.
What is the order?
Got the order of the deputy commissioner for reviewing the order dated 10/9 demand
the earlier order. Date is bit wrong. Lord.
passed by the ADM. The parties are asked people. So it is not a 144. Earlier was the different proceedings,
Earlier,
not a review proceedings. The deputy commissioner may say, go and review this. But the question is, it is 107 proceedings.
and Lordship, the Deputy Commissioner has not said Lordship, because I applied for the copy of the communication, and we have filed an additional affidavit, Lordship, in the matter. It was initiated as per the application of the private respondent.
Obviously.
And nowhere a DCS instructed to review the earlier order.
But he makes a reference to another order. He does not mention the, but this is 11/9 order.
Lordship,
Why? And the case number is also different. Where? MR 138. It's same.
138 Lordship. Top, Lordship, page 19, top. Date, Lordship, may be 1 day wrong.
Yes, who is appearing for the other side? Who are you?
Preparing for respondent number 4 to 7.
Yes, what is there?
But I
We
want
set
to
aside this. We set aside this. If you have any problem, we initiate proceedings under 144, 145.
file our rejoinder. It is a 144 proceeding, Your Lordship. Or
First of all, you see, I say this order, they have passed an order. It's 11/9. This executive magistrate has no business for reviewing. In that same case, he is again passing an order. Means reopening. He has no business. If he wants, he can very well. You are always at liberty to file whatever proceeding you file.
Another expect is also to be looking to Your Lordship.
You, in fact, you cannot.
11/9, it was during.
No,
pandemic,
you,
Your
in
Lordship.
fact, you cannot. Now you need to file a suit. Who is in possession? He is in possession. You have to recover.
No, my instruction is that we are still in position, Your Lord. That's why I want to file my rejoinder.
No, your rejoinder doesn't appear. This is a 2020 matter, 4 years down the line.
I have received notice recently, Your Lordship.
Well, you see, that is your, but then also you should have known, but this court is not going to, this order is bad.
This is the
I'm not
first-
going to say anything.
this is
I'm
the
only
first-
going to say
first
this
day I am
order is,
appearing, Your Lordship.
no, the power of review is not there. Matter ends there, nothing more. Whatever you do, that is your lookout.
There is correct, Your Lordship.
Huh?
That I admit there is no provision for a review in CRPC, Your Lordship. But it was a 144 proceeding, no conversion to 145. Then, Your Lordship, the order was passed during pandemic when there was a restriction from this honorable court. No adverse order should be passed. It was during that period, Your Lordship, kindly see the order, date of the order,
Oh,
11/9.
The council. Why then you have not challenged this order before under that provision, what you call 482 or 407, 397, these are provisions are there. Why you are not challenging this order?
During that,
I give you the liberty, you go challenge this order, what do you feel
in
like?
fact, during that period, no court proceeding was there, Your Lordship, pandemic. COVID pandemic was there. It is during
Mr.
pandemic.
Council, I can't do one thing. I can do many things, but I can't do one thing, bring back the pandemic.
Yeah.
So under such circumstances, what is to be done is set aside this. I will give you the liberty if you are aggrieved to challenge it in appropriate proceedings. File revision against this order. 7-9. Lekhok. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. The Vijay Talukde appears on behalf of the respondent number. So appears on behalf of the respondent number 4,
4
5,
to 7.
6, and 7. the petitioner herein have challenged the order dated 28/9/2020 passed by the Additional District Magistrate Murigaon, whereby a proceedings that is MR, that is case number MR.138/2019, which was dropped, was reopened on the basis of a purported order of the Deputy Commissioner Murigaon. The learned counsel appearing on behalf of the petitioner submits that the order dated 28/9/2020 passed in MR.138/2019 is an order by which the Additional District Magistrate have sought to review an order, the order dated 11/9/2020 passed in the said proceedings, which the said authority did not have the jurisdiction to do so. This court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration. A perusal of the order dated 11/9/2020 passed in case number MR.138/2019 clearly shows that on the basis of a police report, the Additional District Magistrate Murigaon had declared the possession of the petitioner on the disputed land and thereupon dropped the said proceedings. The said order no. Pursuant thereto, on 28/9/2020, the Additional District Magistrate Murigaon again reopened the said proceedings. In the opinion of this court, the said Additional District Magistrate had no jurisdiction to do so. However, however erroneous the order dated 11/9/2020 may be. The said opinion is based on the well-settled principles of law that the power to review is a creation of a statute. Accordingly, the impugned order dated 28/9/2020 passed by the Additional District Magistrate Murigaon is set aside and quashed. Before parting with the record, this court, however, finds it very pertinent to take note of the submission of Mr. So-and-so, the learned counsel appearing on behalf of the private respondents. The learned counsel submits that the impugned order, the order dated 11/9/2020, is bereft of any reasons and was passed at a time when various lockdowns were in operation. He submits that in view of the order dated 28/9/2020, whereby which have been set aside by this court, the proceedings were again reopened. The private respondents did not challenge the order dated 11/9/2020 as per the mandate of law. Accordingly, and therefore submitted that as this court is setting aside the order dated 28/9/2020, liberty will be given to the private respondents to assail the order dated 11/9/2020 before the appropriate court. And the limitation for filing such proceedings may be condoned, taking into account that today only this court have set aside the order dated 28/9/2020. This court have given a due consideration to the said submission. It is apparent that as the order, as the MR, as the proceeding being MR dot 138/2019 was reopened, there was no occasion on the part of the private respondents to challenge the order dated 11/9/2020. And it is on account of the orders passed hearing today that order dated 11/9/2020 in MR 138/2019 had come into again come into existence. Under such circumstances, this court grants how much? 30 days, na? 30 days time from today to the private respondents to assail the order dated 11/9/2020 as per the extant law. EXTNT. It is further observed next. For the sake of clarity, this court makes it clear that the setting aside of the order dated 28/9/2020 by this court shall not be construed that this court had given any approval to the order dated 11/9/2020. The legality and validity of the order dated 11/9/2020 shall be decided in due course. Just keeping this matter pending doesn't help you.
I also observed that there is no scope for review. No scope for review, but it was in pandemic, no court was functioning.
No, you have a good case against that order. The order is
Court was
bad.
functioning. So yes.
But then also that person has no power.
Yes.
Yes, what is this? Lot of affidavits filed. Interim order, Mr. B. Doctor, Mr. B. Yes.
Reply to the.
Huh?
I want to file my reply to the affidavit.
Affidavit filed by whom?
We have already filed, they filed reply. We file additional affidavit in opposition, bringing some photographs. Is there are some environment?
Hello?
Otherwise, it's a
What interim order is there?
interim order, my lord, they have, your lordship,
Go for the further construction to be carried out today.
Huh?
From the further.
In a primary case, and considering the balance of convenience, they have petitioner may suffer in the it is the executive officer shall ensure that during the what matter is this? Interim order is extended.
It is still the pendency of the repetition.
Oh no, I have made it clear. Interim order passed earlier shall continue till the next date. Or till when? 31.
Can be on 24th of September.
What? 24th of September. Chalo. I will do one thing till 31 it shall continue. Thereafter, interim order is vacated and then fix it on 24th. What?
Then can it be on 5th of September?
31. Is construction you have stopped?
It is illegal.
My lord, they have filed a suit and withdrawn it, my lord, civil suit at that stage of cross-examination. Now twisting certain facts, they have filed writ petition. So my contention is that
The permission.
they have not come with clean hands, my lord.
What is their case?
They themselves have not maintained any site back, my lord. They are claiming that we are not maintaining site setback. That is the case.
Who is appearing for Tinsikia development? That is the most important, no? Who is appearing? Service, you are appearing.
For the board.
Last time, these type of matters, I said somebody has to appear. Is the matter again on 5/8? Today is what? Why the matter wouldn't get listed? Interim order is vacated.
It was not.
List the matter again on 5/8. The interim order shall continue till the next date. 5/8.
I will, it not mentioned.
So, there is no extension, no interim order. Go ahead and construct. We have it in the month of January 2025. Give a date, 27th of January. Interim order is vacated. Go ahead, complete your construction. till this.
2004, they are my lord, dragging in the litigation.
till this was-
They
till
have
we-
sought for time in 2023 to file their reply, file your opposition.
No,
Apply
you
for
have
24
already
days.
received it on the last occasion. You filed when?
I-
You filed today. Why should we accept?
I have filed my reply on 7/8.
They already filed, my lord, it's on record.
There is an additional affidavit they have filed.
It has been submitted that an additional affidavit in opposition has been to the respondent number 2024. Learned counsel appearing on behalf of the petitioner seeks for an opportunity for filing a reply in view of the fact that new facts have been brought on light. List the matter again on 24th of September 2024. Same order, so past shall continue. Till then.
19.
এই তেতিয়া যে মই এখনত ভৰাব দিছিলো যে সেইটো জাজমেন্টটো I'm also. Yes. What are you doing? The central bank also.
What's if that the three
All banks
has been
council
filed?
is you. What problem you have with the police?
What's if there was some
You must have given some loan.
ATM as well as the POS machine.
The officer in charge to make etiquette investigation into the
There was
what
there are
what
multiple
complaints?
ATM machines.
Ah.
As well as in the POS machines.
Ah.
Accordingly, 2 crores tax has been taken out from the machines.
Hmm.
Against that, we have filed an complaint application with the Thana concerned. But Thana concerned never investigate into the matter.
So 156.3, go there. The instant repetition has been filed. FIR lodged. FIR lodged. I'm not going to ask all these things. FIR lodged.
23/12/2025.
Number.
Number has not been allotted. Only we have filed an application and thereafter number has not been given to it.
Heard Mr. M. Sharma, the learned counsel appearing on behalf of petitioner, Mr. BJ Talukdar appears on behalf of the Learned Counsel appearing on behalf of the petitioner submits that as regards certain fraudulent
Activities in the ATM machine as well as in the
certain fraudulent activities in the ATM machines. The of FIRs have been lodged before the Kanpur police station on various occasions. However, the officer in charge of the Kanpur police station have not taken any steps in that regard, and it is under such circumstances the instant writ petition has been filed. This court duly takes note of the settled position of law as by the Supreme Court in the case of State of UP versus Sakira Basu reported in so-and-so, wherein the Supreme Court had deprecated entertainment of writ petition in respect to non-registration of an FIR or non-filing of a or complaining as regards improper investigation. And observe that the provisions of section 156(3) of the Code of Criminal Procedure 1973 is an adequate and efficacious remedy. Taking into account the above, this court is not inclined to entertain the instant writ petition. However, if the petitioners are aggrieved by the inaction on the part of the respondent authorities in registration of an FIR or inadequacy of a proper investigation, the petitioners are always at liberty to approach the jurisdictional magistrate under section 156(3) of the Code of Criminal Procedure 19. Yes, any idea, any? On behalf of the petitioner on call, taking into account the for the interest of justice, the matter stands adjourned to be listed again on 11th of September 2024. Then, court directs the counsels representing the respondent 5 and 6. Who is appearing? My goodness. There the problem arises. Notice has not been issued. Who is going to appear on behalf of it? None appears on behalf of the interest. And is adjourned to be listed again on 11th of September. It is made clear if the petitioner is not represented, the matter shall be dismissed for non-prosecution.
21.
Yes, what is this?
In this case, Lordship, page 29 is the earlier order, Lordship, regarding the non-payment of materials bill, Lordship.
Huh?
Non-payment of materials bill, Lordship. Supply of materials, Lordship, for PNRD. Hailakandi district for.
Yes, why you are not paying?
Lordship, some of the part payment was made and rest of the amount because of the FTO in the website was stopped. For which the petitioner is the victim of not getting.
Yes, why you are not paying?
Actually, there's a system here. The system in place
the BDO at the block level, my lord, he uploads all the bills in a software, my lord. It is called the MIS system, which has been created by the Ministry of Rural Development, Government of India, in collaboration with the NIC, National Informatics Center.
Mr. Bordley. Bordley?
The handling.
P. Henry. Mr. P. Henry, I'm not concerned with it. Why are you not paying? Simple question.
That we are not able to pay because the funds have to come from the center.
See that? Simple question, answer is that. You are, what am I going to do with your, how it is to be
But
uploaded?
that
Why it
is-
has not been? File your affidavit, you can't say that this is as regards payment of certain amount.
We have filed an affidavit, my lord, in this case.
No affidavit is here. When did you file?
It's there in the.
Huh?
Is not yet filed any.
Not filed affidavit. You must have thought about some other
But
case.
there is an affidavit, my lord, in the second file.
Don't have any. No affidavit.
Page
Mr.
20.
P. Hendig, appearing on behalf
Page
of the
20.
PNRD department, submits that an affidavit has been filed by the state department. However, there is no such affidavit of the department. Lists the matter again on 9th of September 2024. The respondent, PNRD department, is to bring on record as to why the petitioner have not paid its dues, and record as to whether the petitioner is entitled to the amount so claimed, and if so, why the payment has not been paid. Full stop. The same be filed, brought on record by filing an affidavit by an officer.
But there's one issue that I would like to bring to your kind notice. That the Ministry of Rural Development, Government of India ought to be included as a necessary party, my lord. Because unless they release the funds, we are helpless. So if they-
First, you are to file an affidavit as to whether the petitioner is entitled to, and didn't I say, and if so, why the amount has not been paid? There you answer.
22 and 23.
Yes, what are these?
Without paying compensation, initially, was shown as forest area, however, KAC has filed an affidavit saying that the reserve due process by gazette notification. The gazette notification is also annexed to the affidavit. Now there are more developments which they sought time to file additional affidavit. Now, in the morning, due to some unavoidable circumstances, advocate for the cases request for 1 day accommodation.
Lordship, our additional affidavit is ready and has been sent for vetting. So your Lordship may kindly allow the to be fixed any day.
You have taken their land. Are those their land?
Take.
Yes, Mr. Architect wants to say something.
Lordship, in this case, I have filed affidavit also, Lordship, and two interlocutor application also filed, Lordship, to permit us to go with the project work, Lordship. Last 2 years, project work has been.
Oh,
hampered, Lordship.
no. This
So,
matter needs an
Lordship.
early disposal. This matter has not come up before me, na?
Yes, Lordship.
Huh?
Next week, any date, my lord, along with that IA, Lordship, I have filed.
Now, are their lands been acquired?
Lordship, that area in question, Lordship, that is 29 acres, land, Lordship, that is under the forest, Lordship.
Huh?
That is under the forest, Lordship. Forest
But
land,
the
Lordship.
KAC says that it has been de-reserved.
Lordship, but in the year 1965, Lordship, there is a gazette notification.
Oh, forest.
It is our-
Forest is the best person there.
In
Those
this case,
forest
Lordship,
people are
forest
there.
department is also not a party, Lordship.
What is this? This is reserved and all. If it is it's a reserve forest, de-reserved. When?
In
How can this be
27th
de-reserved?
and 1965, I had gazette notification, my lord.
De-reserved.
Yes, Lordship.
Forest land de-reserved.
Lordship.
For what?
Lordship, for gazette notification is published in the year 1965, Lordship. And land of the petitioner's lordship does not fall within that area lordship. That is
the
forest land lordship.
instruction sought. That is the instruction sought which the KACS.
And due to pendency of this
Lordship
case,
may
lordship,
see, the order dated 1906.
there is a total
That
6
is the
kilometers of
instruction
land
sought.
lordship,
Whether
way
we
lordship.
say that we are patta holders and
Mr. R.K. Talukdar, the learned counsel appearing on behalf of N
And it's IDCL, my lord.
expresses great urgency in the matter, taking into account that for the last 2 years, the project have been withheld in view of the interim order passed here.
But the petitioners and other persons of the locality are obstructing our work. lordship. In
On
this
view
regard,
of the
lordship, we are seeking help of the administration also, lordship.
obstruction caused by the petitioners as well as others in view of the pendency of the instant petition. So taking into account the above, list this matter on 27th of August 2024. The KC is directed to bring on record the affidavits latest by 21st of August 2024. 21st, no delays. Now 21st is the Adiki Day. Okay.
24.
Gravely lordship. And it is a matter lordship. Lordship, earlier lordship, in the first presentation, my name was a dropped off lordship. Therefore, lordship, I filed the registration lordship. Then lordship, they filed a published under notification lordship. And in that notification, my name has come lordship. That notification is currently in page 49 lordship. I have brought in the additional affidavit lordship.
Then what is the case?
Now lordship, only the amount I have not received lordship.
You get the amount. If they don't pay, they will pay interest. Don't worry. This government has a lot of money. Your name has come in bold letters. Bizen Ram Rava.
Yes, Lord.
So nothing remains.
National Health Lordship, they said that they have already paid the money to the.
Mr. Council, do you want this court to go there, get the check, and then to come down and hand it over to you? Goodness. You want to get money, get the money. You will get the money. If you are not satisfied, go and file an inadequacy application.
Lordship, he is claiming that his 1 bighas of land we have acquired. But as per joint survey report, we have acquired only.
Now, Lordship, I am accepting this. Lordship, only 0.04 hectare. That is I
Yes,
have
he
accepted.
also agreed to this.
Yes, Lordship.
He is also agreed to this, Lordship. We have not acquired, in the writ petition, he is claiming that we have acquired 1 bighas of land. But after the joint survey report, he got the joint survey report and he says that we have acquired only 3 kotha and 12 lesa and 1 kotha and 16 lesas for breeze. And for that, Lordship, we have already paid the compensation.
Petitioner, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss Arbora Arbora appears on behalf of the respondent number 2.
1 and 5.
Huh?
1 and 5.
1
And 5.
and 2.
2.
National Highway, you
Yes,
appear.
yes, yes.
1, 2, 4,
4 and 5.
and 5.
7 and 8.
S. Sharma appears on behalf of respondent number 3,
Wait, 1 or
3, 6, 7, and 8. Pustu. From a perusal of the materials and records, it is seen that the petitioner herein is aggrieved. Have filed the instant petition taking a direction upon the respondent authorities to formally acquire the patta land of the petitioner measuring 1 bigha by dag number 106, patta number 8 at village Kharbuja as per the provision of law, and to pay compensation as per the present market value. It is seen from the affidavit filed by the respondent from the additional affidavit filed by the petitioner on 16/8/2023 that the land of the petitioner at measuring 0.048 have already been acquired by issuance of notification under Section 3D of the National Highway Act 1956. Under such circumstances, it is the petitioner herein would be duly entitled to the compensation in respect to so much of the land which have been acquired. Accordingly, the instant writ petition therefore stands disposed. With the observation that the petitioner herein would be entitled to the compensation as adjudged, as determined in terms with Section 3G1 of the National Highways Act of 1956 in respect to the land so acquired. In so much of the land so acquired of the petitioner, as mentioned in the notification dated 17/2/2023. It is further observed that if the petitioner is aggrieved by the inadequacy of the compensation, the petitioner can always have the take resort to the provisions of Section 3G5 of the said Act. With the above, the petition stands disposed. Interim orders, if any. Yes.
They will directed to pay loss within a time frame loss. Any time loss 2 months.
The council, if they don't pay, you keeping it in the bank would not help. My order is there, na, to pay. They will pay. And if they don't pay, we'll catch hold of the, what do you call, the person who is not doing it. They would not dare to do that because they do, if they do it, they will have a lot of problems, na.
25.
What is this? Land acquisition again? Grant allotment of patta upon the land in dark number so and so as granted to other similarly situated persons. Why?
70, they were allowed to cultivate the land, to do cultivation. They have pursued the authority for
What is the stand? Government?
government has not filed any evidence.
Yes, yes. Why you don't have the stand?
The affidavit is ready for filing, my lordship grants me a few days time.
Ms. S. Sharma submits, the government advocate submits that the instructions have been received. The affidavit has also been vetted and would be filed in a week's time. List the matter again on 31st of August 2024. The affidavit be filed on or before 27th of August, 28th of August 2024 by the state respondents.
56.
Hmm.
The petitioner is paying for monetary compensation for the death
For what?
for the death of her husband by electrocution, my lord.
Electrocution.
Matter, my lord.
Yes, where? What is your stand? Electrical accident report given?
Accident
What does
occurred
it say?
2018, my lord.
Huh?
Accident occurred on 3/6/2018.
Good, but electrical accident report given?
Yes. The report
Was
is given.
leading to the Iman
That is running
victim
page
died while the
79,
victim
my lord.
was trying to get the defunct 11 fuse fixed at so and Iman, it was found. Yes.
My lord, the report has not been served upon us, my lord. The affidavit, my lord.
Have a copy of the affidavit?
Sir, copy.
Mr. Counsel, you want a disposal, early disposal. It is not the responsibility of the state respondents because they are not bothered to the record. You should be bothered. Give it to him. One photocopy.
5 and 6, we have filed it.
Understood. But why you are not understanding? Who? It is to whose benefit if you give a copy? Because you see, unless they don't challenge, they are to pay you 4 lakhs. That's your case. But if you don't give, they don't give a copy, the matter is only getting delayed.
Yes, I'll give it to them.
So Mr. So-and-so appearing on behalf of the APDCL submits that they are not aware of the affidavit filed by the respondent number 6 on 31/7/2024. It is also submitted that today, during the course of the day, they have come to learn that such affidavit has been filed, and as such, would obtain instruction as to whether the authorities concerned would like to file an appeal, challenge the electrical accident report. List the matter again on 2nd of September. 2nd of September. Court is closed, huh?
27.
Wait, dear mom.
Thank you, Your Lordship. The matter pertains to non-admitted contractual leave. Day before yesterday, they have.
And you got hold of water resource. Water resource.
Affidavit has been filed, Your Lordship.
They will say that the union is not paying.
And union is not party.
Union is a party.
Oh.
Mr. Counsel, you need to bring Jal Shakti. File an IA. Okay. You have filed the affidavit. The affidavit is not on record.
Filed on 13, Lordship, day before yesterday.
Have they mentioned anything about Jal Shakti?
Lordship, they
Yeah.
mentioned.
The learned counsel appearing on behalf of the petitioner submits that in view of the stand taken by the Water Resource Department of the Government of Assam, he would like to file an application to implead the what is that? Ministry of Jal Shakti, Government of India. List the matter upon filing of such application. You file your application. Huh? I'm not fixing a date. Because otherwise it makes no sense.
28.
If I have to.
Yes, what is
file the
this?
reply, Your Lordship. They file the-
Cancellation of mandate. Which according to it was illegally done and such.
My lord, we have already filed our affidavit, my lord.
For affidavit, we don't require affidavit. Yes, government. What is this? Why it is pending? Cancellation of mutation?
Affidavit for me, file. So far.
They have filed an application for cancellation of the mutation. Now, why the matter is pending? You filed when? 22.
For India affidavit, there is no regarding that,
When was the mutation granted?
it was granted on your lawsuit on 24/8/2021. Thereafter, the petitioner filed an appeal against the mutation order. Your lawsuit will find at page 53 and excerpt 6.
You filed an appeal.
It before the deputy commissioner.
That is pending.
No, not my lord. Deputy Commissioner directed the concerned circle officer, that is Kamalpur Revenue Circle, to dispose of my petition, as I was directed by the Deputy Commissioner while disposing the appeal to file a fresh application before the circle officer, your lordship. That petition is pending. Your lordship will find at page 55. That is
Page 65.
Page 55. Annexure 7. So after the order being passed by the deputy commissioner, the petitioner submitted this application to the concerned circle officer, which is circle, and it is being kept pending.
8:55.
Otherwise comments from them, we drafted an affidavit and sent it back. They have not responded.
No, madam, only one thing. I don't want other way. They have filed a proceeding is pending before the circle officer.
Yes, sir.
Now, why the circle officer is not disposing it of? It has to dispose this way or that way, that's all. The requisition is not going to do anything else. The petitioner herein is aggrieved by the inaction on the part of the circle officer. Which circle?
Kamalpur Avenue Circle, Your Lordship.
Kamalpur Revenue Circle in not citing the application filed for cancellation of the mutation granted in favor of the private respondents. Ms. S. Sharma, the learned counsel appearing on behalf of the district administration, is directed to apprise this court on the next date as to why the said application as to whether the said application for seeking cancellation of the mutation in favor of the respondents have been disposed of, and if not, why so? List the matter again on 9th of September 2024. Only get in that instruction. Once you get that, no affidavit is required this type of matter.
29.
By the learned edition. Round of non-maintainable loss.
Why should this court entertain this petition? Why should this court entertain this petition?
The ground of rejection lordship, that is.
So what? 227 do. Against an order of the district judge, we are going to do it. How many judgments are there of the Supreme Court on this, exactly on this point? An order of the district judge cannot be challenged in a under the public premises, cannot be challenged in a writ.
And lordship next week, lordship.
Huh?
I'll verify.
Next week is with cost. You don't need to bring, there are many judgments. My goodness. At the end of the day, you are not going to get a relief. File 227. Challenge it. Can't challenge this. Making everybody a party. See? What does the district or divisional area head, the deputy commissioner has any problem with them? Dekho. Or Miss P. Bhattacharjee, the learned counsel appearing on behalf, and appears on behalf of the respondents. Appear respondent number 1, 2, and S. S. Sharma appears for the respondent number. Please withdraw.
The liberty to file.
Obviously, liberty I'm going to give. Ms. P. Bhattacharjee, the learned counsel appearing on behalf of the petitioner, submits that petitioners
One petition.
petitioner submits them. He may be permitted to withdraw the instant petition, taking into account that the The proceedings herein is initiated against an order passed by the learned district judge, Additional District Judge Golaghat. However, she further submits that the said order be permitted to be again assailed in the proceedings under Article 227 of the Constitution. Taking into account the above, the instant petition stands closed on withdrawal. However, liberty is given to the petitioner to challenge the order dated 27/1/2000, passed in title appeal number 3/2016 for the 227 of the Constitution. 227 article or 115? 227.
30.
3 January, not 27. 3,
Are you sure?
yeah. Page 23 also.
Where?
Below title appeal number so and so, date is so and so.
31/2000. In orders passed earlier, stand begin.
Please, your lordship.
Yes, what is this?
Corporation Department had sought time to file their affidavit. That is yet to come. The petition was filed complaining against the inaction of the corporate authorities of the respondent municipal corp. As far back as 3rd of April 2023, they said that the instructions had been received. They were to file the affidavit.
Permission granted?
Permission was granted, but the contention of the petitioner has been that the construction is being carried out in violation of the permitted plan. And therefore, there have been damages in his premises, his residential house. And the
There's no
damage
stay.
is also admitted by the private respondent.
There is no stay.
There's
There's
no-
So what will happen?
Only
The
thing was that
repetition
there
is
was
allowed, it will amount to demolition.
if it is in violation, my lord, then
Has to be demolished. They will do so at their risk now. They will do so at their risk.
at their risk. So the municipal corporation had also at one point of time summoned the parties. There were discussions that it should be resolved. But halfway, my lord, they had abandoned the progression of that process. And consequently, my lord, the affidavits are also not exchanged. The private respondent has filed an affidavit and the question of occurrence of damage is also admitted. But they have said that although there are damages, we have taken remedial measures to repair it. The question is, my lord, whether in view of these facts, the respondent corporation can shirk off its responsibility in inquiring into the matter.
In fact, these matters require very urgent disposal. Because any decision this way or that way will affect
Yes.
both parties, no?
Both the parties.
Because if I pass an order in favor of the petitioner, then the respondent is affected. Because if he is constructing, and if I pass in favor of the respondent, the petitioner.
And the emergent situation, my lord, at which the petition had to be moved. Because of the constructions, my lord, the water supply connection was also disrupted. Certain portion of my residential house got into a dilapidated condition.
Oh, when? And the date? Let's have it on 17th of September. Pleadings are complete.
The corporation is yet to file a
The cooperation is very difficult. Something has
what you
happened
can
to
see
the
the order
Corporation
dated third
Council, Mr. S. Bora, is nowhere to be found nowadays. Where is he?
3rd of April order, your lordship may kindly see, 3rd of April 2023. Mr. Nayak said that he has already received the instruction
Oh, Mr. Nayak, he's another problem. It is seen that the respondent numbers, the respondent GMC has not filed the affidavit in spite of various opportunities being granted for the last more than a year. Back in the order dated 3/4/2023, it is seen the Standing Council had submitted before this court that he has already received his. This court is of the opinion that A, in disposal of the incident petition, would have adversarial effect on both the petitioner as well as the respondent. Taking into account that there is no stay to the construction. This is the matter again on 17th September 2024. The GMC is given a final opportunity to submit their reply affidavit in opposition by 6th of September 2024. The petitioner thereupon shall be at liberty to file any reply if such affidavit is filed. On the next date, an attempt shall be made to
31.
eviction. Yes, Mr. Arbiter, you are the main person who evicts people. You have evicted them. No stay was granted, therefore the petitioner is not appearing. Eviction must have happened. And appears on behalf of the petitioner on call. Seen that the petitioners herein have challenged the notice dated 29/10/2021, whereby the petitioners were directed to vacate the land village Ulubari Part 3 is a land identifiable.
Schedule is not here, and what is most striking here, if lordships, what is most striking here, this notice is issued under 18(3). Lordship may be pleased to come to page 16, that is the vernacular. Issued by the.
It's okay. Otherwise, your 18(3) has become useless. But anyway,
18(3) because.
But whatever may be, they.
So now post Salakuddin, my lord, whether 18(3) will be attracted, that is, of course, my lord, I am not going to that. Affidavit will be required, my lord.
However, there has been no, interim stay order has been passed by this court to the said eviction notice. List this matter again on 28/8/2024. It is observed that if the petitioner is not represented on the next date, it shall be presumed that the petitioners have lost interest in the instant proceedings. and appropriate orders. And just find out what has happened.
Therefore, my lord, since this interim notice is issued by the circle officer, an affidavit from the circle officer.
Not necessary. This type of affidavit is not required as to whether you have evicted or not. There is no stay, na.
No, my lord.
32,
I'll
33.
follow up, my lord.
Yes, what is this?
Aye.
Yes, this is a very important matter. What has happened? How much land? What is the stand of the government? You file the affidavits.
Okay. File our affidavit. Procedural, kindly turn to the page
There is a status quo order.
98 in my affidavit.
Hmm?
Para 9, look, the affidavit filed by the respondent number. Respondent number 2, Lord.
The petitioner is entitled to get allotment or settlement of land. He will get the same, but not as desired by him, and as the plot of land for which his cultivation is required. But this matter needs an early disposal. What are you doing? You are cultivating only. So there is no house. They will give you some other land. Find out which plot of land you can give, how much land. They can't get more than a particular land.
Earlier it was, my lord, I think it was 1 bigger. Now, my lord, it was, my lord, as per new amendment, lordship. It is, my lord, that increased. Lordship, may I kindly praise to 99 annexure 1 in my affidavit.
19?
99.
Now how much for agriculture?
Most of it is,
In 1.4
Yeah,
area after the words and before the event and half and word and before the word because shall be substituted by 7 and 1 respectively. Now how much?
this, my lord, for agriculture, this actually is 7. And, my lord, for outside, my lord, is 1.
For homestead is 1.
In the, my lord, that the rural area.
Okay. So under such circumstances, you need to find out. They will.
Para 9, my lord.
We do one thing. Let us fix this on 31st. We dispose of the matter. You see, they have to go ahead. These status quo orders can't remain for that. You don't have anything, they will provide you. They have submitted in Vasundhara. In the meantime, you just find out as regards the application. List the matter again on 31/8/2024, on which date an attempt shall be made to dispose of the incident with petition, taking into account that an urgency has been expressed by the state authorities in view of the status quo order. Pustam. The council appearing on behalf of the district administration, Mr. J.C. Hendig, is directed to obtain instruction as regards the status of the applications seeking allotment of filed by the petitioners.
Other matters we taken together. Similar
Which one?
matter.
There are two matters, 5706 and 5731.
There are another 2 matters.
Okay. It has been also submitted that there are 2 other petitions pending, which are numbered as so and so and so and same also be listed on the next.
34.
Very good. Dismiss করে দিব No. তো সেইটো গাড়ী পোৱা 2 লাখ Dismiss. Give your names.
Five.
There's a miscase, IA Milo, file Milo for impleading pursuant to honorable court order dated 12/6/2024.
IA filed.
IA file, another IA is there.
IA has come. Whom do you want to implead?
There's, Secretary, Department of Housing, Urban Milo, Commissioner Secretary.
Leading the Commissioner and Secretary, Department of Housing
GMDA.
and Urban Affairs. The GMDA represented by MDA is not available. Anyways, why do you want to make them?
Also, there is the order, Milo, main case, there is the order of 12/6/2024.
Six.
That Milo in paragraph 2 in my petition, Milo.
An
Person was
application
received-
filed by the petitioner to implead the whom?
Milo,
The opposite party number 4 and 5 of the instant application as respondents to the accompanying writ petition. The necessity to do so have arisen in view of the submissions so made by the Standing Council of the Revenue Department on 12/6/2024 and the order so passed therein. So taking into account the above, this court impledes the opposite party number 4 and 5 as respondent numbers 4 and 5 to the accompanying writ petition. So the petitioner is directed to file a fresh memo of parties before the registry of this court and by 19th or 8th, 2024. And on the basis thereof, necessary corrections be made to the cause title by the registry as well as shall update the same in the CIS. Main view. In view of the orders so passed in interlocutory application, the newly impleaded issue notice to the newly impleaded respondent number 4 and 5. Gustav, it has been duly submitted that the respondent number 4 and 5 has a standing submitted that for respondent number 4 and 5, Mr. P. Nayak is the standing counsel. The petitioner is directed to serve extra copies of the writ petition upon Mr. P. Nayak, the learned counsel, by 19th of August 2024. Let's the matter after 4 weeks. Okay?
Six to 39.
Yes, what are these?
Pertains to rejection of my bid on technical mallet.
Huh?
Grounds mallet, rejection of my bid. I'm
Your bid? What has happened?
They've rejected my bid, my lord. First,
Site
initially it
department.
was accepted, my lord. Alright. Initially, my technical bid was accepted, my lord. However, they have again done a re-scrutiny and again.
For what matter? Excise what?
Tender, settlement of the
IMFL?
offshore.
Offshore. Okay. And offshore for how IMFL offshore is who? This is for perennial, no? It remains. It's not hereditary. Okay.
Item 36, my lord, we have filed an affidavit today, my lord.
All are
Which is
different
supported.
applications or all, yeah?
Two are together, madam. Two are from the same, madam, two reasons. And in respect of the Gilapokri, of same. Others are, my lord, different, not of the same. But it relates to excise.
35 to
39.
no, 36, 37, 38, and 39. You are appearing for the private respondent, Mr. Alway? And in which matter? 37 and 38.
38. And these are from, the same shop, my lord.
Why it has been rejected?
On technical ground, my lord, they have cited that
Have not submitted bank proof, my lord.
Huh?
Item number 36, it was rejected, my lord, with a note that rejected due to non-submission of proof of bank account.
Oh. And
That is the only, my lord.
all of you,
But in two writ petitions, my lord.
same bank account not submitted. And others?
My technical bid has been rejected on two grounds. The envelope was not marked as hard copy and the IT return was not submitted duly certified by a chartered accountant. I have submitted computer generated copy. But the same gown was accepted in respect of Tinsukia district. So there is a discrimination in of Sunitpur and Tinsukia district. They have filed affidavit stating that in respect of Tinsukia district, they have rightly accepted the IT return, which was not certified by the chartered accountant, that was computer generated. But in respect of
Who is the accepting authority? The
Central
district
Federal
administration.
district collector,
Oh.
they have taken two different steps, and therefore my tender has been rejected. So my tender value was 51 lakhs, but same has been settled with only 14 lakhs.
Well, we need to dispose it of then early. When? You want to delay? Very well. There is no stay. No stay. Huh?
Operating in favor of the bill.
All
No, no. In my case, there are no stay, my lord, they put this-
the stay. So that is why he wants to file a reply.
We have already deposited our.
You have a good case. Why do you want to file a reply? Anyways, I was fixing a date, but seeing your intentions, I need to fix early. Okay. When? Arrive at a consensus. When?
My case, private respondent has not filed a affidavit, but district collector and superintendent has filed it.
Okay, no, they file or not file, for me, it doesn't matter. You see, the hard copy has not been written unless the tender conditions mandated that it should be written, then matter goes. That's the only question.
That is
Why
a
do
clause,
I
my
need
lord.
to go
There are
further
some
beyond
minor
that?
irregularities, then
If
can
it
be
is a
called.
case where the IT, it has not been mentioned that the IT returns has to be certified by a chartered accountant, it is not being mentioned, and they are imposing them, then obviously it's bad. They can't come up.
There is one more ground, your lordship.
Yes.
Yes, not, there's, in the form of the, where they apply, they have to fix a code sem as per rule 63, which the petitioner have not done. That's also another ground we have rejected.
That is a, no, therefore my question is, this is nothing to do, it is a very simple question. As to whether it is mandated out there, if it is mentioned, ground and you have rejected, I have no business. But if it is not mentioned, but you are rejecting, then hidden criteria cannot be the basis. Nothing more than. It doesn't take much time, but I don't have the time today. When? Mr. Agarwal, when? 11th. 11th is a Wednesday.
Or Thursday, 12th Thursday also. we already-
Hello, 12th. Councils appearing on behalf of the parties, some of the councils appearing on behalf of the parties expressing urgency in view of the fact in certain cases there is a stay operating, and in certain cases there has been no stay granted. I have submitted that the petitions be taken up for disposal at an early stage. Post of taking into account the above, list this matter again on 12th of September 2024. In which cases interim orders? Huh? Interim order passed in 38. 38 and 39 does not have an interim
No
order.
interim order.
Huh?
No interim order in 39.
35, 36? No interim order. 36 and 37. 38, interim order is there. Interim orders passed in WPC number 1384/2024, 1385/2020, and WPC number 1496/2024 stands extended till the next date.
Okay.
What? The counsel for the respondents, more particularly the respondent number 2 and 3. Now, Mr. J. Hendrick, the learned counsel appearing on behalf of the respondent number 2 and 3 shall obtain instructions as to whether the land of the petitioner have been acquired or is in the process of being acquired. This the matter again on 6th of September. Just get that instruction. Because this court can't direct anybody for acquiring unless you acquire it.
41.
Tell me, madam.
File their affidavit.
Affidavit not filed. Interim order also.
We have not received any instruction.
Huh? They are not filing an affidavit as an interim order. Is a very eviction has been stalled. It is seen that no affidavit has been filed by the respondents. This court have also inquired as regards instructions, which is also available. This is the matter again on 18th of September 2024. The interim order passed earlier shall continue till then.
42.
Matter is fixed. Instruction and
Yes, what is it?
filing an affidavit in this case.
Whether there was a signature, that is the case, no?
Apart from that,
It's the beach.
Subsection 4 issue are also. Subsection 4 of section 11 of AGST Act.
That is not the point you have urged here. No,
But
no,
barred by limitation.
no, you have not. That cannot be done. You not. That might be a case of action taken under 71. Yes, Mr. Bora. We have been searching for you in all the other matters. You are not there.
I have my life in the.
Huh?
I related to P. I have my life. That's right.
I got it.
Not take a last chance for filing. I will inform him.
Huh?
I will inform him.
Okay, please inform him about this. He's not here. Yes.
Lordship will be filing an affidavit in this case. We have received an
So then I have to stay. You can't go for that. Today is fixed for passing of the interim orders. These basic two folds. One is, first, the petitioner was not issued a show cause notice prior to passing of the order as to whether the attachment included that. Secondly, that the notice which was issued and the order which had been issued was not signed. This is the simple question where I've asked. Why do you need to file an affidavit? Show me that order.
Regarding that signature and all,
Yes.
instruction says that these are all digitalized. So there is no physical signature. So digitally, the name is there. It has been issued by the so and so.
That's it. That is the only thing is required.
Yes.
I don't require anything else.
Well-
And whether that aspect was brought inside. You see this. As far as the first issue is concerned, Kerala High Court is what this regarding. There is no physical. Whether there is a digital signature. That's all.
Yeah, very clear from that.
Where?
Well, it
Just
says-
produce that. You see, just produce the digital signature, printout of the digital signature.
No, it
that-
it says,
Because digital signature has a number.
the last para of this. They have framed the three queries and the reply.
Eh.
Regarding the.
Through his digital signature, so
Yes.
kindly take out a printout of with the digital signature and show it to me, matters.
Yes, sir. That I can place on Monday.
Have it on Monday.
Lordship.
Just produce that matter. We will dispose
Yes,
it.
correct.
That is the only ground.
And so cause notice, whether they have issued so cause notice.
Show cause notice, get the show cause notice where there is a digital signature as well as so and so.
Fine.
Mr. B. Gogoi, the learned counsel appearing on behalf of the Finance and Taxation Department of the Government of Assam submits that the digital signature is there in the show cause notice as well as also in the order. In that regard, certain instructions have been placed. Taking into account the above, list this matter again on 21st or no, 21st of August 2000. We'll have it on 28th. No events will fall to him. He has come solely. On 28th of August 2024. In the meantime, the respondents shall be bring on record by way of an affidavit the show cause notice as well as the order which have been digitally signed. Interim order shall to be considered on the next stage.
43.
Hey, the tax matters all come at the last moment.
Kindly call the last order, my lord. Is
Yes.
it fixed for consideration of interim prayer, my lord?
Then it says to whether the order Iman has been passed.
Here I have got the parawise comment, I will file a short affidavit any day next week, on Friday next.
Now, have you passed the order under 73(9)?
Yes, 73(9).
Order has been passed.
Regarding personal hearing, only one point, I have found, it says that, though a prayer was made, it was inadvertently missed out. Regarding personal hearing.
Prayer was made, but it was inadvertently missed
they
out.
stated that. So, and I will file an affidavit. I can
Then,
file it Monday,
then the problem arises, what happens to this order then? Order of which year?
106, my lord.
Huh?
Page 106.
Financial year?
And
10?
17, 18, 19.
1819. When was the order passed?
Of January 24, my lord.
This is the notice. The order has been passed.
It is a summary of order, not order, my lord. There is
Huh?
Lordship will find it page 106, my lord. They have uploaded summary of the order.
That order is not there, but order has been passed, no, Mr.
Yes.
Huh?
Yes. I have annexed the screenshots, my lord. Lordship last time.
No, no, understood, but that is what I asked him. So let him file an affidavit to the effect.
Lordship protect me in the meantime.
Mr. On the same date? Earlier
Yes, sir.
matter is on 28 August, huh?
28.
Gusto. Mr. B. Gogoi submits that the order under section 73(9) of the AGST Act 2017 was duly passed. And in that regard, he would like to file an affidavit, short affidavit giving details as regards the queries so made in paragraph number 4 of the order dated 7/8/2024. Also, list the matter on 28/8/2024. Also, interim order. The prayer for interim order shall be considered on the next date.
52.
Lordship, hearing this matter, Lordship, we have received instruction, Lordship,
Ah.
and Lordship, we have filed, Lordship, the affidavit has been signed and notarized in test school, Lordship. The messenger is bringing it to the Guwahati, Lordship. So, Lordship, let it come.
Superman, the learned counsel appearing on behalf of the health department submits that the affidavit is in the process of being filed. Full stop. I list the matter again on
Yeah, the 31st.
31st? On 31st of August 2024. So in the meantime, the petitioner would be at liberty to file any reply.
Review.
Any urgency, any?
Item number 50, Lordship. Respondent, Lordship.
It will give.
Right.
Petition दिए नहीं हुआ, no? ऐसे तो भाई वो बोलना है, no? It's up to you. What is it? Oh,
One contract work is going on, Lordship.
Oh, that matter. Yes.
I'm appearing for the railway authority, Lordship. And the main allegation, main grievance is that, Lordship, that construction has not been done from the boundary of his land, Lordship. That one sketchmap has been sent by the authority, Lordship. Here, Lordship, it has been done from the boundary, Lordship, because, Lordship, there is a boundary wall. Thereafter, there is a 6 feet wide, that blue line, 6 feet wide, Lordship, that is a village road, Lordship. And thereafter, they, as per their non-process, they have to vacant for safety purpose. 2 meter they have to keep vacant. Then they have constructed that road, Lordship. That constructed that structure, Lordship.
Wait, slowly. Now, these are what are these to be? High tension?
So high tension, this is a power supply line, Lordship.
Okay,
for
this.
electrification.
And where is his house?
His house is not near, Lordship. His house is some other place, Lordship. No, 200 feet more.
They have their own house also, by the way.
No, here. This is the boundary wall.
This is the boundary wall, Lordship.
Whose boundary wall is this?
Some other person's, Lordship.
Okay, and then this
Then
is
the
it.
blue line is, Lordship, that is a village road, Lordship.
Huh?
6 feet wide village road, Lordship. That is a small village.
Village road. And then
Then
this.
the red mark, Lordship, that is they have kept vacant, Lordship, because of the safety purpose, Lordship. So there is no.
You do one thing. You do one thing. File a short affidavit, bringing on this, and whether the petition is affected or not. Once you file that affidavit, when can you file? Next week?
Work is also very urgent, Lordship, because it is.
That is why I'm asking you, because you have to say that you are not touching the petitioner. The moment you say that on affidavit, the petitioner's grievance is already settled. He has no right.
On Thursday next Lordship. On next Thursday, Lordship.
Okay, I'll fix it on 22nd. And you file your affidavit by 21st. Okay, I just want it on affidavit that you are not touching the petitioner's this land.
Then is the Lordship. We are touching the petitioner's land and the other grievance of the petitioner is that Lordship. It is not that we are touching his land. Their grievance is that Lordship. We are constructing that portion in the middle of his land, Lordship. In the middle of his land, but as per my drawing, Lordship, we are not constructed that portion in the middle of his land. It is in the boundary land, Lordship.
You put it on the affidavit. Okay. Mr.
Yes, Locker.
P.S. Locker, the learned counsel appearing on behalf, standing counsel of the railways.
516 Lordship.
Railways.
CG Central Company Council.
Standing counsel of the railways submits that he has received the instructions and would like to file a short affidavit on that on the said aspect of the matter. Full stop. He expresses great urgency, taking into account that there is an interim order. Full stop. List the matter on 22nd of August 2024. At the top of the list, the affidavit be filed on or before 21st with advance copy to the petitioner. We take this.
Till 22nd.
Yeah, the status, the order so passed, the interim order so passed on 7/8/2024 is to continue till the next date.
My Lord, 47.
What?
And petitioner
Seven.
in person, my Lord. The service upon respondent number 3 and 4 has been completed. Service of notice, my Lord, has already been completed upon the respondent number 3 and 4.
Then it should come up for admission. 47 to likh diyo. The learned counsel appearing on behalf of the petitioner. You are the petitioner. The petitioner in person submits that the service upon the respondent number 3 and 4 is duly complete. He therefore submits that the service is being complete, lists the matter for admission. The taking into account that the service is complete, lists the matter for admission. After 2 weeks. Anything on? No more, na?
Regards to my Lord, that my Lord, from my Colgate Fastech wallet from my Lord Gujarat, whereas my car is my Lord
Any more? What is that?
There's several opportunities given back to the GMC for filing their response. Till date, they have not filed it.
In the meantime, the original record has misplaced and the FIR has been lost. My lord, we need some time to construct the reports, my lord. Also, up to 3 weeks, my lord.
Respondent, Mr. Espora, appearing on behalf of the respondent, submits that the original file have been misplaced for which an FIR has been lodged. He submits that there is a process going on for reconstruction of the records. Therefore, he submits some more time would be required for filing the affidavit. Accordingly, list the matter on 23rd of September 2024. In the meantime, the affidavit be filed by the respondent departments as well as the GMC on or before the next date. 46, what happened?
Service complete. Admission. Our official dated 8.
বনাইছিল নেকি এইটো? 46. 46 service being completed, list the matter for admission. Urgency? After 4 weeks. And 4. Application steps for people. Court have duly taken note of the office to be again listed on 6th of September in the column of no steps. 6th of September, first at 2 p.m. And everybody is represented.